New what? Yes.
My lord, may I be permitted to mention the matter? It's for the withdrawal. It has been wrongly.
Deputy, admission is not required. Then you will get a spanking from the court.
My lord, it's for the withdrawal. I have been
Yes.
wrongly.
Please,
this.
whatever it is. Yes.
And I'm also praying for the return of the original certified copy.
We'll do that when we take other. Yes.
My lord, may I be permitted to mention item number 150, which is today listed before your lordship?
Upgradation we are generally not allowed.
No, my lord. It is actually, my lord had directed for substituted service in this matter. My lord, I have done the same, but I was a bit late in filing the paper publication in the department, my lord. Now the Honorable Commission is saying that unless, because it is before your lordship.
It will appear as to be mentioned on Monday.
Deeply
We'll pass necessary office.
The restoration application.
Yes.
150.
We'll continue this side, then come back. Yes.
My lord, this item number 149, my lord. Extreme urgency is that the respondent are demolishing the existing property. We have filed for application for restoration property of our property. It is this appeal came for order.
File for restoration means it's already demolished.
No, they have took possession, my lord. What happened in this?
You wait for
No, my lord. What happened? This appeal came from order 12 rule 6, and we couldn't.
Understood.
But they have took the possession, or they have started
taken the possession
construction,
already.
my lord. My lord, restoration of possession is required, my lord.
Not right now.
My lord,
Yes.
to be mentioned on Monday, my lord. Kindly take it up, my lord.
No.
This matter, my lord. This is a running business, my lord. The bailiff has come and taken possession yesterday, my lord. My lord, what has happened is, despite orders of this court, my lord, if my lord sees the.
Sir, please wait for some time.
My lord,
We're not upgrading matters.
Sir.
Upgraded matters are stalling the regular hearings.
155 of the list, my lord.
Every day we cannot upgrade a matter. Sorry, no. Yes.
My lord, today's
From that side. Yes, yes, ma'am.
My lord, item number 194, my lord, today's list, they have already started demolition, my lord, without any proper notice or any order of.
Started demolition. It is still going on.
My lord.
This will appear on Tuesday as upgrade matters. Give a slip. Yes, you.
Yes, my lord. I am permitted to mention, my lord. Today's list, item number 25. Under instruction, I am withdrawing this application, my lord.
When it is called on mention? Oh, actually 20. We may not.
25, item number 25.
See, if you can't reach it today,
Yes.
then it will appear as to be mentioned on Monday.
Oh,
If
my
you can reach it, then mention them.
My lord.
To be mentioned Monday দিয়ে দেবেন call করবেন যদি
May I have lordship's kind leave to mention one application, my lord?
Yes, yes, application.
Kindly to mention matter, my lord, for inclusion in the list, my lord. In the month of May, we have
What hearing?
My lord, it's an order from the district judge, my lord. We had filed an.
What is the stage of the hearing?
My lord, there's a stay, my lord. We have taken the position. There is a
You are
position,
mentioning
my
for
lord.
inclusion what, an application or for hearing or what?
Application.
Yes.
Lordship, may I be permitted to mention one matter? This is a first appeal for admission.
First of all, admission is not required. Yes.
Application under 40.
Don't renew. Sorry, but right now we are not.
Business.
We fully appreciate, but I mean, come back next week.
Kindly appreciate.
Try your luck next week.
Single bench has already set aside the impugned order. Just because they have done jurisdiction lordship, they send back to the.
We understand your agony also, because several matters we are refusing also today. We are not being able to reach the regular list. So let us do some matters, then come back next week. Try your luck. We are not assuring you, but try your luck next week. Next.
Grateful.
Call on the list.
Item 1, my lord, I am for the respondent. I am led by Mr. Bhattacharya. My lord, I have prepared the written note as per
Oh,
your lordship's
okay.
last direction.
Mr. Mahathir, you are filing a written note.
I have prepared it, but it requires some correction.
When can you file it?
If I correct it and hand over.
During the course of the
Yes,
day.
yes.
You are for the respondent.
Respondent state.
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 Oh, you are for this. Achha. The written notes of arguments filed by the state be kept on record. First up, learned counsel for the petitioners seeks leave to file the petitioners' written notes of arguments during the course of the day. First up, such leave is granted. First up, the matter is reserved for judgment. Some other, please ensure it is given. And just write on a slip of paper the item number when you file it. Yes. দিলে এর মধ্যে ঢুকিয়ে তারপর পাঠাবেন।
Item number.
For release by Mr. Rai?
My lord has appeared for one of the parties.
Oh, Mr. Rai, can you please give your phone number on a slip of paper to our officer?
Lordship.
Yes. Learned counsel for the appellant submits that one of us, within bracket আমার নাম, পুরো নাম, appeared for one of the parties while at the bar. First up, accordingly, for the sake of propriety, let the matter stand released from our list on personal ground with liberty to the parties to seek an assignment from the Honorable the Acting Chief Justice before a different bench. এই ফোন নাম্বারটা নিয়ে আমাকে পরে দিয়ে দেবেন, মানে আমাদের দিয়ে দেবেন। Yes.
Sir, I appear for the
লিখে দিন
appellant.
phone number।
Mr. Siddhartha
দিয়েছি,
Banerjee was
দিয়েছি
leading.
ওখানে বাঁধকে। Sorry, miss. Yes, Mukherjee.
Well, Mr. Siddhartha Banerjee was leading me in this matter. Well, this is relating to that where KMC had handed over possession to my client. Well, we had sought a better order of injunction than what we had received.
Oh, yes.
The learned trial court had granted us an order of status. We had substantially, Mr. Banerjee had concluded his submissions.
Yes, yes.
Respondent number 5 had also concluded. It was really Mr. Kaur will now submit for the respondent number 1 as a.
Let him submit.
Yes.
Yes, Mr.
The plaintiff, Lord, has acquired title
Yes.
in a sale, Lord, conducted by the bank under a surfacey action.
Mr. Kaur, you are for?
For the respondent numbers 1, 2, 3.
Acha.
1, 2.
1, 2, 3.
1, 2, 3.
You are the
I am the original owner,
Owner.
and Lord, the borrower.
borrower.
I had mortgaged the property.
Yes, yes, yes.
And Lord, the sale has been conducted by the bank. Now, Lord, there are two aspects of the matter. One is with regard to, Lord, the sale.
Right.
Which is, Lord, already under challenge in a Section 17 application that we have filed before the tribunal.
Right.
DRT. The other aspect of the matter
Yes.
is with regard to the possession. Lord, that is also an issue in a Section 17 application where, Lord, my learned friend's client have become a party. They have got themselves added as a party, and that proceedings is pending. I'll show your Lordship, Lord, in course of my argument, what is the order that the tribunal has passed. Now, Lord, the right to possession comes from, number one, his sale certificate.
Yes.
I'll request your Lordship to first, Lord, may I just give your Lordship a few dates first, and then, Lord, take your Lordship to the sale certificate.
Yes.
Lord, broadly, Lord, in March 2008,
yes,
the loan was obtained. And against mortgage, Lord, mortgage was created. Then, Lord, there are 3 dates which are relevant. One is, Lord, 16th of May 2019, 11th of April 2019. Sorry, Lord, 11th of April should come first.
Yes.
Lord, the properties are, Lord, a showroom on the ground floor and, Lord, 2 office space on the first floor. They are situated at P18 CIT Road. Roughly, Lord, the area is about 4,500, 4,800 square feet, roughly. Now, Lord, on these 2 dates, 11th April and 16th May, Lord, a registered lease was executed by the owner, by me, granting lease for
2 lease deeds.
2 lease deeds, because, Lord, these
For the ground and office.
all the three separate documents for these 3 properties.
Yes.
Granted, Lord, lease for 30 years from the respective dates. Lord, I'm not troubling your Lordships with the dates. It's a 30-year lease, registered lease.
Right.
Now, Lord, the lessees in turn have granted a sublease. This sublease is also a registered document. 11th of October 2019. Now, Lord, on 29th of September 2024, the KMC, Lord, issued a distress warrant. This was with regard to non-payment of certain dues in respect of the properties, corporation municipal tax.
The sublessee is respondent number 5.
Just
5.
They are all made parties by the plaintiff. Plaintiff has implemented everybody.
Yes, yes.
Because my lord, these facts,
You are
he is a lessee.
you are 4 respondent.
5. Lessee is the 5.
And who is
Sublessee is not a party.
Acha.
It doesn't matter, my lord, really speaking, but
the timing? Yes.
yes. So, my lord, then what happened was on 16th of October 2024, a notice under section 13(2) was served by the bank.
KMC, a bank.
Bank. This is my lord, now the surfacey action.
Yes, yes.
The bank had served my lord, earlier a notice sometimes in July 2024. That's not important because I'll go by the plaint. I'll go by the plaint. Now, my lord, this 13(2) notice was served in October 2024, followed by a notice under 13(4) on 28th of January 2025. Then, my lord, 10th July 2025, there was a notice of e-auction fixing 19th August 2025 as the date of auction. Then 20th August 2025, I find that this sale certificate has been issued. So I take it that on 19th August, my lord, the sale was confirmed. Subsequently, sale certificate was issued. And this was subsequently also registered on 21st August 2025. Now, my lord, 10th September 2025, Lord, I find that there was a mutation in favor of the purchaser. Now, my lord, 22nd of September 2025, KMC, it is pleaded, my lord, has desealed the property and handed over possession to the plaintiff. This is paragraph 14 of his plaint. And page 81, he has also annexed the desealing process, plot, the minutes, etc. I'll just show that.
80?
Page 81. I'll not take your lordship to that. Then, Lord, they lodge a police complaint on 30th October 2025. And this is, Lord, very important because, Lord, 30th October 2025 is a date, Lord, subsequent to 22nd September 2025, when they plead that they had the property was desealed, etc.
Police complaint against you.
Police complaint, kindly come to page 85. Lord, kindly come to page 86. Fourth paragraph. I'm sorry. So, stay petition, Lord.
আমরা এফিডেভিটটা দেখছিলাম।
Lord, kindly come to page 85, the subject portion.
No,
Your Lordship,
85 of
I'm so sorry.
we are looking into something else.
Briefly tally.
ইনজাংশনটা গোড়াতে আছে বলে তাহলে এইটা ইনজাংশন এইটা
I'm sorry, injunction application, Lord.
No, you're right. We were looking into the wrong. Yes, page 85 it starts.
Page 85 it starts. Kindly see the subject note. The complaint is against me. The directors, I mean, one of the directors, I think,
Yes.
respond number 2, Suresh Goel, and Lord, respond number 3. Kindly turn the page, come to page 86.
Symbolic position. This.
Yes.
You place this on the list. Yes.
So, Lord, this is what he admits on 30th October 2025. He says that he is in symbolic possession. The bank has not delivered physical possession, but the bank has given symbolic possession. Now, Lord, then he filed an application under 163(2) BNSS. Now, Lord, that 144. The order is at page 92. This is not what the order is. I've really not been able to understand, Lord. It says no illegal activity to be done by the OP at the suit property, SP. This is what the order is.
Yes.
Then the suit is filed. Lord, I'll place the plain plot. I'll not trouble your lordship. And the impugned order was passed on 1st December 2025. So between 24th November 2025, when the 144 application was filed, there were about 6 days, 7 days by which this suit was filed. And in the suit, there is a specific pleading that Lord corporation has given them the possession. Now, Lord, there is a section 17 application which was filed on 6th March 2025. And Lord, my learned friend has heavily relied on this section 17 application, saying that I have admitted that the possession is not with me. I will place that application. Lord, there is a prayer for recovery of possession.
March 25 it is filed.
6 March 2025. This is post filing of the suit. I'm sorry. 26 it should be. I'm sorry.
Achha, 6 March.
I'll just check. Lord.
Should be 26.
I could be wrong.
Everything
26. Kindly correct that.
right.
6 March 2026, I filed this section 17 application.
Yes.
My learned friend is heavily relying on this application. I am also heavily relying on this application because Lord, unless I say that I am dispossessed, I cannot ask for recovery of possession. In the section 17 application, this is Lord a categorical prayer in the section 17 application where my learned friend is a party, where I said that I am entitled to recovery of possession. Now, Lord, on the facts, just Lord, 5 minutes, 5-10 minutes, please come to the sale certificate. That is at page 49. Sorry. First, Lord, come to page 59 and then, Lord, I'll come back to
59. Yes.
This is the certificate and then, Lord, that's the register. Lord, kindly take 59. Your lordships will find it says, kindly take the second paragraph.
Yes.
And whereas the undersigned being the authorized officer of so-and-so under the Securitization Act and in exercise of powers conferred under section 13, read with rule 8 and 9 of the Security Interest Enforcement Rules 2002, sold on behalf of Reliance Assets Reconstruction Company Limited in favor of the plaintiff having address at so-and-so, the immovable property mentioned in the schedule below, secured in favor of Reliance Capital Limited, so-and-so, so-and-so, towards financial facilities advanced to the said borrower. The undersigned acknowledges receipt of sale price. And then, Lord, the description of the immovable property. There are 3 properties. First, Lord, the showroom. Then is the shop number 3 and shop number 4. Now, if your lordships, Lord, kindly take the 2002 rules.
Yes.
And come to Appendix 5.
Yes.
Kindly give me 1 minute. 2002 rule, Appendix 5. Yes. Page. Lord, kindly see this is appendix relatable to rule 9 sub rule 6 of the security interest rules.
Yes.
which says that, I'll just read it for your lordships. On confirmation of sale by the secured creditor, and if the terms of payment have been complied with, the authorized officer exercising the power of sale shall issue a certificate of sale of immovable property in favor of the purchaser in the form given in Appendix 5 to these rules. Then, Lord, please come to Appendix 5. Lord, there is two significant averment missing in the sale certificate. Your lordships may kindly note that. One is, if your lordships kindly, Lord, come back to Appendix 5, lordships will find around the middle, just the sentence starting with the word, the undersigned acknowledge the receipt of the sale price. Has your lordship found that? Just below the middle.
Yes.
The undersigned acknowledge the receipt of the sale price of rupees such and such in full and handed over the delivery and possession of the scheduled property. The sale of scheduled property was made free from all encumbrances.
So handed over possession and free from encumbrances is missing.
Missing.
Yes.
Now, Lord, if your lordships kindly come back to the registered instrument.
Page 40.
At page
49.
49.
Yes.
49. Look, the operative part of the document is at page 54.
As is where is.
As is where is. Because, Lord, the sale certificate does not mention that they have handed over possession and that it is free from encumbrances. Obviously, Lord, the sale deed could not have, Lord, contained this. Now, Lord, the question may arise as to why, even after the sale being conducted, the bank did not write this. Lord, the answer your lordships will get in one of the Supreme Court judgments, Lord, which is reported in 2019, volume 9, SCC.
What is
page 94.
94. Yes.
Lord, if your lordships kindly come to paragraph 12. This was not a precise issue that was raised before the Supreme Court. What happens if there is an existing occupant or a lessee or a sublessee who has come into possession prior to the issuance of section 13(2) notice? The Supreme Court says that you will have to terminate the lease before you can approach to take possession. Lord, I'll just, Lord, place 2 or 3 paragraphs out of this. First, Lord, kindly take paragraph 12. It acknowledges, Lord, section 65A of the Transfer Property Act, which the owner, Lord, retains a right to lease out the property, so long the notice under 13(2) is not received. Once the notice under 13(2) is received, then, Lord, it changes the complexion totally. The right disappears. In fact, your lordship has already, Lord, gone into this issue in the other matter, that Julian Day School, where, Lord, I argued this point, the Lordships upheld my contention
Hmm.
insofar as this is concerned. So here, Lord, the 13-2 notice is the most important factor. And Lord, bank post 13-2 did not, Lord, take possession. Even after the sale, the bank could have resorted to section 14. Bank could have, Lord, terminated the lease, proceeded to, Lord,
Section 14 was not filed
no,
at all.
I don't know, Lord, whether 14 was resorted to.
Filed probably. Anyway,
But I at least from the plaint, I don't find that they had resorted to it. On the contrary, the case in the plaint is that they have not received possession through the bank. I'll Lord,
from KMC.
from KMC, paragraph 14. Now, Lord, if your Lordships kindly take paragraph 12 of the judgment, says section 13 of SURFACE Act provides for enforcement of security interest. This is a self-executory mechanism for the bank. Once the process of realizing the secured interest takes place, the secured creditor acts as trustee having de jure symbolic possession of the property and is required by law to realize it strictly in accordance with the provisions of section 13, 14 and 15 of the SURFACE Act.
Mr. God, we have read this paragraph. So you say after 13-2 notice, then cannot further sublease, not prior to anything.
Not prior to, and Lord, your Lordships will find the discussion is there. If your Lordships kindly come to 17.
Yes.
It says, if your Lordship sees placitum D, I don't know, Lord, if placitum D is there.
It is there.
It's the secured creditor. It's just above that. After noticing the scheme of the act, this court held that if the lawful possession of the secured asset is not with the borrower, but with a lessee under a valid lease, the secured creditor cannot take possession of the secured asset until the lawful possession of the lessee gets determined, and the lease will get determined if the secured creditor chooses to take any of the measures specified in section 13 of the SURFACE Act. Accordingly, this court concluded that the Chief Metropolitan Magistrate, District Magistrate can pass an order for delivery of possession of secured asset in favor of the secured creditor only when he finds that the lease has been determined in accordance with section 111 of TP Act. This is maybe one of the answer why section 14 did not fructify. Then, Lord, please come to paragraph 18. This is again, Lord, Chief Metropolitan Magistrate. Kindly see placitum F. In case, has your Lordship found, he comes to the conclusion there is no valid lease either before creation of the mortgage or after creation of the mortgage satisfying the requirements of section 65A of the Transfer of Property Act, or even though there is a valid lease, the same stands determined in accordance with section 111 of the TP Act, he can pass an order for delivery of possession of the secured asset to the secured creditor. So, my Lord, 65A needs to be satisfied before the magistrate. These are the tests, Lord, which is laid down. Then, if your Lordships kindly come to para 20. 20, your Lordship can ignore. This is Lord Harshad Govardhan's case that has been, Lord, reiterated. Just, Lord, if your Lordships kindly take placitum C under para 20, the sentence starting with the word hence. If any appellants claim that they are entitled to possession of a secured asset for any term exceeding 1 year from the date of the lease made in his favor, he has to produce proof of execution of a registered instrument in his favor by the lessor. Where he does not produce proof of execution of a registered instrument in his favor and instead relies on an unregistered instrument, then Lord Chief Metropolitan Magistrate can go ahead and pass the order. Then kindly come to 22. After examining the legal and constitutional position, the court held that while SURFACE Act has a laudable objective of providing a smooth and efficient recovery procedure, it cannot override the objective of the Rent Acts to control the rate of rent and provide protection to tenants against arbitrary and unreasonable eviction. To resolve this conflict, this court held. Then, Lord, I am not troubling your Lordships, kindly come to paragraph 24. In our view, the objective of SURFACE Act coupled with TP Act and the Rent Act are required to be reconciled herein in the following manner. And then, Lord, the court gives a guideline as to how it is to be reconciled. Kindly see 24.2. If a tenancy under law comes into existence after creation of a mortgage, but prior to issuance of a notice under Section 13(2) SURFACE Act, it has to satisfy the condition of Section 65A of the TP Act. And then this is how the questions are answered. Now, paragraph 27 may also be taken note of. The claim of tenancy made by the appellant tenant is not supported by a registered instrument. Here, the Supreme Court did not believe the tenancy because it was not supported by a registered instrument. But here, there are registered instruments, both the leases as well as the subleases. So, that being the position, the question was that it is not the bank's claim, not the plaintiff's claim that they have obtained possession through the bank. Now, a purchaser who is not a deriving title through the bank cannot have a greater right than the bank. And he has to also follow the same procedure as is prescribed for the bank. Now, your lordships may kindly have a look at my application under Section 17. But I believe my learned friend had handed over this Section 17 application separately. No, I am talking about the document that has been handed over to court. ঠিক আছে, all right. যেটা দেখিয়েছে কোর্টকে সেটাই আমরা দেখাই। Yes. Your lordships may kindly come to paragraph 17 first.
অন্য কাগজ এটা নেই
আছে, extra copy আছে। I have an extra copy, can I?
এখানে তোলা নেই।
তো কপি দিয়েছিলি না? একটাই দিয়েছিলি।
We'll take an extra copy from you.
It's slightly marked, kindly.
No discussion. Yes.
Please come to paragraph 17, 17. Your petitioner states that in the year 2017, paragraph 17, page 6.
Yes.
The petitioner company leased out premises to so-and-so for a period of 30 years by registered lease deed, and on 29th September 2018, when Kotak Mahindra Bank left the premises without paying the holding rent to the secured creditor, the petitioner approached the lessee for payment of an adjustable advance with interest at the rate of such and such to enable them to deposit their outstanding KMC tax, and simultaneously they deposited KMC tax of a sum of rupees 50 lakhs, which is kept in suspense account. After that, the Kolkata Municipal Corporation sealed the aforesaid premises under Section 195, read with 225 of the KMC Act 1980. Thereafter, the lessee, Messrs. So-and-so, is taken legal steps against the sublessee so-and-so, and the learned court passed a status quo order in this regard. Copies of KMC seal photograph, etc., collectively marked with letter C. Then, your lordships may kindly come to paragraph 24.
Yes.
On 7th of February 2025, the petitioner number 1 company received by post a forwarding letter dated 28 January 2025 together with possession notice dated 25th January 2025. it is evident from such documents that on the date of taking over symbolic possession, no step was taken by the defendant number 1 and 2 to serve the possession notice upon the petitioner company, and such a mandatory provision had blatantly been violated. Anyway, these are not issues to be adjudicated not before the tribunal. Kindly not come to paragraph 29.
Yes.
Your petitioner states that the defendants have deliberately omitted to mention in the said notice the encumbrances of the said property. I would say, my lord, they have kept silent, because, my lord, in the sale notice, they have not mentioned at all that it is free from encumbrances. The dues of the Kolkata Municipal Corporation in respect of these three properties had remained unpaid for a considerable time. The KMC, in view of such default, has taken over physical possession of the three properties of the petitioners on 27 September 2024, and since then, physical possession of the properties are with KMC. Then, your lordships may kindly see paragraph 35.
Yes.
Your petitioner states that the property of the petitioner was sold on symbolic possession basis. However, recently petitioners have come to know that the defendant number 4 has started civil construction inside the aforesaid property. Your petitioner's representative visited the place to verify such information and found that the flooring of the property has totally been damaged and the civil work is going full-fledgedly. Your petitioner's representative took photograph of the property at the time of visit. Then, Lord, please take paragraph 39, 40 and 41. But I'll not trouble your lordship with the total paragraph. You kindly see the last three lines. I have said that this possession is wrongful and illegal. And in gross abuse of the provisions of the Surface Act. This is not my ground taken in the section 17, the interim application. These are all not to be considered. Paragraph 40. Where I have said the defendants are not entitled to legally take possession. It is pertinent to mention that one portion of the property, so and so, had obtained an order of status quo from the learned City Civil Court, which is still in force. On inquiry, petitioners have come to know that no notice regarding taking over physical possession of the defendant number 1 and 2 in respect of the aforesaid property of the petitioner number 1 has been served on such lessee. Then 41, petitioners submit, it appears that the defendant number 1 and 2 in violation of the order of status quo had handed over the physical possession of the aforesaid property of petitioner number 1, defendant number 4, who is causing damage to the property.
So portion of the property was leased out. That portion regarding status quo is regarding that portion.
Regarding entire portion, because this
you have stated in para 41 portion of the property.
One portion, not because the suit was restricted to that.
I have stated it is pertinent to mention that in one portion, one measure such and such was lessee.
Yes.
So they were lessee in respect of one portion.
Lessee in respect of one portion has moved the City Civil Court. He had obtained an order of status quo.
So the status quo paradigm is regarding that one portion.
One portion, but Lord, I am asking for recovery of the entire possession before in the section 17 application before the DRT.
Yeah. So you have several grounds. Status quo violation ground is restricted to the portion which has been leased out.
Correct.
And violation of other provisions of the Surface Act Rule 8 and all, that pertains to the other portion, as well as this portion.
Yes. And Lord, kindly see the prayers, my Lord, consequently, apart from the setting aside of the sale, please see prayer D.
Physical person.
Now, my Lord, kindly have a look at the plaint.
Mr. Kaur, we can understand the lessee could have had a right. But how do you have a right after getting to notice?
I am the owner of the property.
Where? Where the owner?
I was.
You cannot reopen the sale also.
No. I have challenged the sale. Sale is itself under challenge under section 17. And Lord, I am a defendant in the suit. I have been pleaded as a defendant in the suit. So I am being
sued by the lessee.
By the plaintiff, the purchaser.
Oh,
In the purchaser suit, purchaser has implemented me as a necessary.
Status quo was passed in which suit?
In a lessee suit.
Lessee suit.
That is not there. Yes. That is there. So far as the DRT is concerned, DRT order. the order passed by the DRT, my lord, I just wanted to show your lordships.
All the orders.
Third.
Pochish order number, right?
Lord, kindly see the order dated 25th August 2025.
Yes.
Essay application filed with the prayer for implement of the purchaser in the proceedings. Applicant submits that the name of the purchaser is so and so. Learned counsel for the respondent bank has no objection. Prayer is allowed. Applicant is directed to appear before the learned registrar for implement of the purchaser in essay proceedings. Registrar is directed to facilitate this amendment. The purported sale which has taken place on 19th August shall be subject to final adjudication in the IA challenging the purported sale. IA so and so is disposed of to 12th September 25 before registrar for implement of the purchase. And Lord, 12th September order is the next page. Your lordships will find that purchaser has been implemented. So, Lord, the sale is subject to the final disposal of the Section 17 application, including the issue of possession. Now, Lord, kindly have a look
up to the last order which you have given to us.
Yes.
Service was not completed on them.
They had not. Yes, service was not
Service was
completed.
not completed. It is seen that neither Reliance nor auction purchase is duly served.
Then,
That's
Lord,
the last order.
fresh summons was issued, Lord, on 11th of November, and then, Lord, 17th December.
Yes. Neither
has
nor
been served.
Duly served.
1 day's time to file complete affidavit of service. Prayer is granted. 19th December, fairly top of the list. তারপর 19th December কি হলো? Service complete হয়েছে না হয়নি? I'll take instruction.
We'll talk about it.
Yes. Now,
So, but subject to outcome of this.
Subject to outcome.
That order is.
Both the issues with regard to possession, with regard to blood sale,
Yes.
both are blood subject to outcome. Blood, there are sufficient grounds to challenge the sale. I'm not troubling your lordships with regard to that. Now, Lord, kindly have a look at the plain now. The plain plot your lordships will find at page 23. But I think, Lord, my learned friend has produced that interim application. That interim application that your lordship looked at, Lord, and Section 17 application.
Section 17 we found.
That IA application was produced by my learned friend. So I presume that they have been served with the they have
Must have been.
Must have been.
It's not a certified copy, so must have.
No, it's not a certified copy. I presume, Lord, they have been served. I suddenly struck me in that.
Yes, yes. Did not strike us actually. Yes.
Lord, kindly take the plain ones.
This is the suit where the status code of the impugned order has been.
Impugned order. Lord, this paragraph 12. I'm বলছি interim order টাই বলছি. Lord, paragraph 12 says upon execution of the deed of sale certificate, the plaintiff discovered that the substantial property tax dues were outstanding in respect of the suit property with Kolkata Municipal Corporation, and that on such basis the concerned authority has attached the suit property. Thus, the plaintiff also paid such property tax dues pending against the suit property. Then the plaintiff states plaintiff has got its name mutated in the name of the records of the municipality. Then 14. the plaintiff states that by a letter dated 19 September 2025, citing that the payments were already made towards pending tax dues by an order dated such and such, Kolkata Municipal Corporation desealed, deattached the suit property, delivered vacant possession of the suit property in favor of the plaintiff. Look, this is his right of possession, and this is how he has gone into possession. Now he wants to secure this possession. He has got an order of status quo from the trial court. Now, my lord, he wants to secure it by obtaining a prohibitory injunction order, which he has got as an interim measure, as an ex parte matter. Your lordships have considered.
That is ex parte.
That's ex parte.
I
That
don't
is not.
think.
Now, my lord, if I may just, lord, formulate my points. Lord, my first point is that neither the bank nor the purchaser has any right of possession in respect of the premises, going by the law as it stands. Even if I accept that at this stage the sale is sub judice, the DRT is looking at it, but irrespective of the sale, the possession is a standalone situation. And
so even if they have physical possession, that is not a legal position.
That's not a legal possession. And therefore, my contention would be
no injunction can be granted to protect it.
This is one. My second contention is that when the issue, the entire issue, including the issue as to possession, is not sub judice in a section 17 application, Lord, section 34 of the Securitization Act would apply.
Part 2 civil suit.
Part 2 going to the suit.
Alright.
My third submission is that, Lord, the remedy that the petitioner had was never resorted to. Remedy in law that the plaintiff had was never resorted.
Section 14 and all.
14, 15.
Yes.
Termination, Lord, 65A, because, Lord, the lease are protected by section 65A of the Transfer of Property Act. So, therefore, Lord, insofar as the 65A right is concerned, that cannot be overridden by taking possession from KMC and, Lord, then rushing to the court and trying to secure, Lord, that possession by filing a suit and getting an order of status quo. And, Lord, my last contention would be that this is a completely misconceived suit, which is filed to bypass the proceedings, Lord, of before the DRT, because, Lord, he realizes that the possession that he has taken is an unsustainable possession. So, Lord, he tries to secure his possession by filing a suit and getting an order of status quo. And therefore, Lord, my submission is that I am resisting this order for the simple reason because this will prejudice, Lord, my application pending before the DRT under section 17, both with regard to the challenge to the sale as well as possession.
But you have not preferred any challenge to the status quo.
Not yet, because insofar as the status quo order is concerned, if your lordship kindly have a look at it, it also protects my right. Both parties have been directed to maintain status quo.
All right.
But with regard to maintainability of the suit, that stage hasn't come for us because, Lord, this is all happening at the ex parte stage. So, Lord, I have not yet taken out an application for raising a point of maintainability of the suit. If my lord looks at the interim order that is of course modified by your lordship, but the original
No,
interim order.
our order is only ad interim at
This
district.
is
That is not
only
binding even
temp-
at district.
Absolutely. There's no doubt about it. I'm saying that the ex parte order that was passed, it says that it protected both parties' right. It says status quo
Yes.
protected both parties' right. Now, my lord, only one issue with regard to whom the possession shall be handed over. Lord, so long the right of the sublessee or the lessee subsists, it will go to them. Possession will go to them. In case their right is forfeited or the lease comes to an end, it would have come to me. It cannot go to the purchaser under any circumstances.
So you say, suppose you are taking an extreme case, even if the current owners, although their ownership is in challenge, as of today they have a sale certificate, they have a deed. Current owners put in the amount corporation dues. The possession should have been handed over to you who was in possession.
Correct.
Let them be the owner. Let them have that released from the KMC. But the possession, physical possession, has to be given back to you.
Should have come back to me under any circumstances. Either to me or to the lessee. Either way. I mean,
not you, the lessee.
I mean, lessee. The lessee.
Not even you, yes.
No, not me. A lessee. But, my lord, it is my specific case that 50 lakhs I have deposited, which they have kept in the suspense account.
What is your locus standard to seek possession on behalf of the lessee?
I am not seeking possession. I am just pointing out.
You are challenging the possession. The entire thing, section 17 you have filed, understood.
Yes. I am here. I am resisting, Lord, a prohibitory injunction.
Because in the section 17 you have challenged the sale also.
Yes.
So therefore you may have a locus standard, because if the sale goes, everything goes.
Absolutely. And Lord, in any event, I am saying that the lease is protected because lease has been granted by me. And I have asked for restoration of possession in that section 17 application also.
You also cannot get that restoration of possession.
No. When it comes to delivery
through
yes,
lessee.
when it comes to delivery of possession, Lord, it will go back to the lessee.
You say that, but that's not your prayer. That through the lessee or something.
No, I have said restoration of possession. I have asked for restoration of possession.
Let us see the language of that.
Kindly see, Lord,
from your section 7.
Prayer D.
D, yes. In favor of petitioner number 1, to you.
Yes, I have asked for restoration, but that may not be granted by the court because, Lord, that is what happened. If I may just cite this judgment, Lord, this is exactly what happened in that Howrah Mungolahat matter.
Yes.
Lord, if your lordships, Lord, kindly have a look at this. This is reported in 2001, volume 6, SCC, page 512. Judgment is in service, Pavi. Kindly take that para.
Yes.
30 and 31. But this was a case where a question arose after, Lord, the requisition failed. A question arose to whom the possession should go back. But here, the lessee's right has been stood extinguished by reason of expiry of the lease.
Okay.
So just take paragraph 30 and 31, your lordship will understand, Lord, the text in which this is delivered. The court said that possessory right was not enough. You have to have a legal right, and therefore directed that the possession should be handed over to the owners. Paragraph 31, after placitum G, your lordship will find the discussion. So, Lord, this exercise the tribunal will do. This exercise the tribunal will do. There is no doubt.
There may be a distinction between a transfer property lease and a rent control act lease.
Correct.
Because in case of the latter, Mr. Kaur, obviously, unless the eviction decree is passed, legal
That
possession
is, that is what the
becomes a
Supreme Court,
statutory.
that is what the Supreme Court has said. It is protected under Section 65A. So if you, even if they are terminated.
But your tenant, your lessee was a transfer property act lessee.
Yes.
Registered deed and all.
Yes. And that lease is subsisting.
Yes, yes. Unless they terminated, no question. Here there is no
That
termination.
lease is subsisting. There was no termination. There was an expiry. But I am saying that this exercise, because question came from your lordship that you have asked for return of possession. That's
To
why,
you, yes.
to me, to my client. That is why, Lord, I thought that this exercise will be done by the tribunal. It's not that tribunal will, Lord, blindly direct that possession be handed over to me. But Lord, I am really, Lord, harping on this at this stage, the prohibitory order, which, Lord, my learned friend is seeking.
How does this judgment help you, Mr. Kaur?
This judgment helps me only. I wouldn't have cited this judgment in a normal course. Because your lordship asked me that question, that the restoration of possession I have asked for in my favor. How can that be given by the tribunal? I am saying the tribunal will do the exercise at the stage of handing over a possession. If tribunal directs handing over a possession, tribunal will find out to whom it is to be given. Because if there are rival claims, the tribunal will decide that. But that is not an issue now. I am saying that maybe I shouldn't have cited this at all. It is totally out of the context. But Lord, what I am.
And you may also submit probably that Mr. Kaur, that recovery of possession is a consequential rate.
Absolutely.
So that does not determine the texture of the section 7. You have challenged the sale and the other things.
Absolutely.
And the handing over of possession in the first place.
Yes. And handing over a possession, Lord, apart from the sale, even if the sale is confirmed.
That challenge still remains. Apart from the sale also, even if it's confirmed, the handing over of possession, if it goes, if that goes, handing over of possession is set aside, then it reverts back to whoever was there.
Huh?
In fact, Lord, this is one of the reasons why I have been impleaded. Because, Lord, the purchaser realized that, Lord, this issue at one point or the other will come up with regard to his possession. Because this is one of the issues that is to be also adjudicated in the suit. I am not going into this.
Suit relief will just once check.
Relief, kindly, Lord, have a look. Page 23 it starts, and 32. The declaration. These are all, Lord, in aid of his possession. Prayers ABC, they are all in aid of his possession. Basically, he wants to, Lord, forestall the proceedings before the DRT.
His sole right to possess, which it seeks a declaration regarding, that is on the strength of the sale certificate, which in turn is sub judice under section 70. So that's why section 34 also comes in.
Yes. I am citing that Supreme Court judgment saying that even if he has a sale certificate, that does not itself give him right to possess. His right to possession has not arisen as yet.
Because his declaration is regarding right to hold, possess, enjoy and deal.
Yes.
Sole right to hold, possess, etc.
And that is already sub judice, Lord, in the proceedings before the DRT. Lord, these are my submissions.
So anyway, you have already argued. Yes. So we'll take reply from the region. Yes, yes.
Lord, the written notes of arguments, we were supposed to give it today. I am at fault. Kindly, can I have, Lord, 1 or 2 days extra?
The rest of you have filed written notes.
No, my lord. Since
So all
Mr.
of you
Kaur-
will give you a date. All of you file on that. You have filed.
We made it ready after induction of Mr. Kaur. My lord, we were a little scared. My lord did not submit.
He was objecting to my accepting this brief. We sit in the same library. He said that you can't accept this. I said, why? Because I am
But I
applying.
simply said this amounts to Moshamartha Kamanda. That's what we submitted.
Deeply obliged. May I have my lord's kind?
Mr. Banerjee, don't say that. That admits the weakness of your case.
No.
Weakness of mine
Your
as a counsel.
Mosha. Oh, you are Mosha and he's
Yes,
come on.
yes.
No intention. The counselor, personal. Yes.
Milord, kindly take two things.
But
Milord,
I never underestimate him. But this is one mistake a gentleman made. I told him, don't ever underestimate him.
All right. So Mr. Chakravarti and Mr. Mondal did not also. Yes. Yes.
Kindly take Milord two things side by side. Milord, the affidavit in opposition of the respondent number 5. And Milord, section 65A of the Transfer of Property Act. Because Milord, Bajrang says, if Milord, the
Yes.
lease is post-mortgage,
Right.
but before 13.2, Bajrang says, Milord, if lease is post-mortgage, but before 13.2, must comply with section 65 capital A. Otherwise, Milord, he is not entitled to any protection.
No.
Now, Milord, kindly take section 65 capital A.
Yes.
Subject to the provisions of subsection 2. So, Milord, subsection 1 is subject to the provisions of subsection 2, which has supremacy. A mortgager, while lawfully in possession of the mortgage property, shall have power to make leases thereof, which shall be binding on the mortgagee. Then comes, Milord, subsection 2. Every such lease shall be such as would be made in the ordinary course of management of the property concerned. Milord, he himself was running a business. Mortgage the property. Milord, there was Kotak Mahindra Bank then. Milord, it will come back to my lord's mind. There was a tripartite agreement where Milord Kotak was supposed to pay me the rent on his Milord consent. Milord, I can again refer to the tripartite agreement. So, Milord's ordinary course of business, there was Milord a clause, restraint clause. Milord, I'll come to that.
No, difference is between ordinary course of business and ordinary course of management of the property.
Correct. So, Milord, ordinary course of management
Your
of the
ordinary course of business would mean something else. Their ordinary course of business would mean something else from the ordinary course of management of the property.
Milord, I am on this clause only because of the tripartite agreement. Milord, the ordinary course which was decided, ordinary course of management which was decided and recorded in a written instrument was that Kotak would remain in possession. And if you want to evict Kotak, you will inform me first. Because Kotak was supposed to pay me the rent instead of paying it to my learned senior friend's client, so that, Milord, the unpaid dues are paid off. That was the arrangement in ordinary course.
Not to you, to the bank.
Yes, I'm sorry.
Don't
to the bank.
confuse.
To the
Serious
bank.
confusion. Yes.
Sorry. To the bank.
Ordinary
Yes.
course of business would
So,
be to bank.
Yes. Number 1. Then Milord, clause C. No such lease shall contain a covenant of renewal. Now, Milord, kindly turn to page 36 of the affidavit in opposition. Clause 2, last 2 lines.
Yes.
Milord, breach of section 65A of the mandates of the statute. So, Milord, this lease cannot be, Milord, sustained in the touchstone of section 65A, in the touchstone of Milord Bajrang. Then, Milord, kindly take E, small e. In case of a lease of buildings, Milord, this is a lease of 2, Milord, office spaces and a godown. Buildings, whether leased with or without the land on which they stand, the duration of the lease shall in no case exceed 3 years. My learned senior friend has argued this was for 30 years. And my lords will also get that in the same page, page 36, first 2 lines. Bajrang, I think.
All right.
So, my lord, this is not a lease that, my lord, fulfills, my lord, the conditions of 65A. And if that be so, Bajrang does not come in his aid at all. My learned senior friend was, my lord, showing paragraph 25.2 of Bajrang, which says, my lord, 65A has to be complied with.
So you say 65A has not been.
Not at all. My lord, there is a breach. Now, my lord, kindly take the IA, which my learned senior friend has also, my lord, quoting from him, my lord, my lord, seriously relied upon, heavily relied upon. Kindly, my lord, turn to page 2 of IA. My lords have, my lord, kindly taken notes of the dates, my lord, which my learned senior friend has indicated. Now, kindly take, my lord, page 2 of the IA, which is also now, my lord, relied upon by them. Kindly turn to paragraph 5. The said Reliance Capital Limited subsequently issued notice of demand under 13.2 on 18th October 2016. Kindly, will not take a note of the date which, my lord, my learned senior friend has indicated as notice of, my lord, date of notice of 13.2. So, my lord, here the lease was even after 13.2. So, my lord, it goes with the wind. And it's not only his case that there was a 13.2 notice. Kindly take then paragraph 6 of IA. My lord, he responded to it. Now, my lord, kindly have a look at section 13, subsection 8. My lord, there is a statutory bar. Once, my lord, one is slapped upon a 13.2 notice, he cannot touch the property. My lord, there was a phrase 13.2 which my learned senior friend was relying upon. But till such time phase 13.2 was issued by, my lord, the asset reconstruction company, my lord, the previous 13.2 remained. My lord, it was a case where loan portfolio was sold, my lord, by the bank to the asset reconstruction company. And after that, asset reconstruction company under section 2QB, 2QA, my lord, issued a phrase 13.2. Kindly, my lord, turn over the page.
What was the date of the new 13.2?
The date which, my lord, my
This-
learned senior friend has supplied. But, my lord, what is omitted to be mentioned is the previous 13.2, which remained in force till the new 13.2 was, my lord, issued.
And the lease was executed in the interregnum.
17, 18. My lord, I'll come to that also. It
Lease was executed in the interregnum during
Yes.
subsistence of the prior.
Yes, when the first 13.2 was there operating. Two provisions, my lord, 13.8 and 13.13. Just kindly take note of this statutory bar imposed on them to even touch the property. Now, my lord, kindly take.
Achha, Mr. Banerjee, one question may arise, which may be a bit subtle, maybe a bit far-fetched, but you answered that also.
Yes, yes.
Because suppose you give a section, subsequent 13.2 notice is given.
Correct.
Earlier one is given a go-by.
Yes.
Now, there are two propositions which come up here. Alternative. One is that as you were submitting, till that was issued, the second one was issued, earlier one is forced. So, at the point of time when that deed was executed, there was a 13.2. There was a bar under 13.8 and this. But it may be argued alternatively that by it goes from its inception.
As if it were never there.
Never there. Never there.
I have an answer to it.
Yes. Because
My lord,
it never
what was
culminated
done-
in anything.
Correct. What was done under the second 13.2 was, my lord, the first 13.2 was withdrawn from that date.
Shows that. Very
The
important.
13.2, my lord, must be
Very
with them. I don't have a
Yes,
copy.
32 you said something?
13.2, my lord, must be
What
with
13
them. Nahi to.
No, is it annexed anywhere? This
No,
date of
my
13?
lord, they are privy to that.
So how
Which
do
is
you-
why they, no,
how do you know that?
purchaser.
How do you know then that it was it cancelled from that date?
My lord, that's what usually, my lord, is
Bank is a party here.
no.
In the suit, bank is not a party.
No, because bank is not restricting my access.
So we don't know that.
Well, till such time.
So how
Milord,
do you
it's
say
not-
that it was?
That's Milord, what? Kindly take Milord page 3 of IA also. Kindly have a look at paragraph 8.
Yes.
Milord, it had progressed further. There was a possession notice also issued, Milord, by the original bank. So after this, Milord, possibly this question, the query that has fallen from your lordship.
That was given a go by subsequently. Even new 13.2 is issued. Everything previous to that goes. It's waived.
Milord, can't go like in a manner as if it were never there. Milord, I become a secured creditor. Milord, now it's Milord, my Milord baby. I issue a 13.2 notice. But the previous 13.2 does not go. It stands withdrawn. Milord, unless Milord, the onus is Milord discharged by them to show that Milord, this was superseded in a manner as if it were never there. Milord, I believe Milord, the onus is on them. When in their own application, they are referring to the previous 13.2. Milord, possibly the onus is on them.
My lord, the following paragraph shows there is a chronology of events because after the 13.2 my learned friend is mentioning, there have been, my lord, transaction between the respondent number 1 and the secured creditor, my lord. Thereafter, which after that failed, then in 2021 in paragraph 13, my lord, the following paragraph shows the chronology of events, my lord, that has taken place in that application.
Milord, I'll show those chronologies. Which has not been shown, Milord, I'll show. Milord, there was a possession notice. There was a section 17 application also filed.
This is a default.
Milord, page 8, paragraph 8.
This
Milord,
is a default.
Milord, since new
This is a
13.2,
default.
correct.
Yes.
New 13.2 came. Milord, they did not, Milord, they abandoned that proceeding, started with a new proceeding.
For abandoned caution.
So, Milord, I have twofold submissions on this. Milord, the best possible case for my learned senior friend and the worst possible case for me is this, that there was a lease post-mortgage, but before 13.2. Then compliance of 65A was mandatory.
So you argue on both?
Both.
Even if that be so, 65A is not
Even,
compliant?
Milord, the weakest possible case for me is against them. Milord, does not, Milord, aid them.
Very.
Now, Milord, kindly take, Milord, the 2002 rules, Appendix 5, which my learned senior friend has, Milord, shown to your lordship. আমার বইটা
Yes.
আমি মার্ক করলাম কোনটা আমি এটা কার বইয়ে মার্ক করলাম My learned senior friend has submitted that there was two significant things Milord missing from this Milord form. One is
Delivery of person and encumbrance.
Correct.
Yes. What is your answer?
Yes. Milord, Supreme Court has answered this. Supreme Court has said, and my learned senior friend has, Milord, accepted that proposition, that position of law, that even after, Milord, the sale is concluded, sale certificate is registered, bank can file section 14. So, Milord, if that be so, Milord, it can never be a statutory requirement that, Milord, the possession must be taken first, must be indicated in the sale notice, and then only, Milord, the sale certificate can be registered. So, Milord, this is not a requirement of law. This is just a form. Milord, we have relied on a decision 2018, volume 15, Supreme Court cases, page 99.
Which para of that speaks about Section 14 being maintainable after.
Yes, Milord.
Just give the para. and just- You have already cited that.
Milord, I believe we have. Oh, no.
You will cite.
Milord, I'll cite two decisions on that.
But in rejoinder, your
Milord, that is Milord accepted by my learned senior friend. Also, will formally cite two decisions on
you
that.
did not cite their accepting.
Milord, my learned senior friend has submitted that Milord, even after Milord, the sale is done, Milord, section 14 Milord can be taken resort to. That has been a specific submission today. Milord, I'll cite those two decisions formally, immediately. Milord, that's the position of law. Milord, there cannot be any quarrel with that proposition. That Milord, even after sale, section 14, Milord can
They
be.
quarrel. They may be quarrel somehow.
Milord, I'll press immediately. Milord, my learned friend, Milord, junior is Milord, searching for that. Milord, immediately.
We'll give them limited reply on that if necessary.
I'm
Yes.
sorry.
We'll give them limited reply on that.
Yes, yes,
That judgment
Yes,
only,
yes.
if necessary.
Yes, Milord. So I say that, Milord, this is not a requirement of law. Now, Milord, this form, Milord,
What was the
refers
name of that judgment? 2018 judgment?
ITC
ITC,
Limited versus
ITC,
Blue
right.
Coast.
Blue Coast. Blue Coast hotels ছিল না। তারপরে 24-এ হয়েছে। তারপর চট্টগ্রাম জাস্টিস তপব্রত চক্রবর্তী ডিভিশন বেঞ্চ। Now, Milord, this form refers to Rule 9.6. Kindly, Milord, time to Rule 9.6 and kindly see whether Rule 9.6, Milord, makes it a Milord sine qua non for the bank, Milord, to take possession first and then to sell. It does not. So, form cannot, Milord, supersede rule. And rule cannot, Milord, supersede act. It's not the requirement of the act that, Milord, possession must be taken first. Milord, second point which, according to my learned senior friend, was missing in the form was, Milord, encumbrances. As regards, Milord, the dues payable to KMC. Milord, these encumbrances must be known to the secured creditor. When my learned senior friend is arguing that, Milord, these encumbrances were not reflected, he has a duty to discharge before this honorable court that, Milord, these encumbrances were known to the secured creditor. That is what the qualification is.
It's a registered deed. Aren't you supposed to know by operation of caveat emptor doctrine?
Milord, whether caveat emptor would apply or caveat vendita would apply, Milord, that's also, Milord, a question of, Milord, argument.
Sale.
Issue and argument.
It's a sale all this.
Correct. Milord, the sale notice said as is varies. Milord, I accepted.
That casts a duty on you to inquire.
Correct. Milord, I inquired. Milord, I was agreeable to pay the dues. I have done so. Milord, I am not, Milord, asking any
The registered sale deeds.
Yes.
Both the deeds were registered.
Registered, my lord.
Yes.
This deed as well as the serve listing.
Correct. Correct. But, Milord, I saw.
So the
Milord,
Transfer Property Act also it operates as a notice also registration.
Correct. Milord, Milord, saw
Picked
that
up the
665A is not complied with. So, Milord, this lease, it is not, Milord, valid.
Yes.
Milord, I have no dispute with the bank.
No, delivery of possession and encumbrance, both your first argument applies also. Appendix is only form and 9.6 does not mandate either. Delivery
And
of
this is
possession
not for the
or
civil
encumbrance.
court to decide. DRT is insisting over the matter. DRT will decide, Milord, whether possession was properly taken.
That takes us to the next question.
Yes, Milord.
Civil Code.
Yes. Now,
Section 34.
kindly have a look at Section 34.
Yes.
Section 34 has two-pronged, Milord, bar.
Yes.
One is no suit and one is no injunction. Two-pronged. Where, Milord, DRT has jurisdiction to decide.
Yes.
Now, DRT has jurisdiction to decide only under 17. 17
Modalities.
comes only when 13.4 I am aggrieved by.
Modalities are complete.
Milord, I am not aggrieved by 13.4.
No, the language of 34 is no civil court shall have jurisdiction to entertain any suit or proceeding. Not relief dependent, but dispute dependent.
Yes.
In respect of any matter which our DRT is empowered by to determine.
Correct.
Now, you raise a question on the strength of your sale certificate. At that point, sale deed. At that point of time, there was a section 17. There was a section.
Not known to me first, served later. And my lord, my only allegation that forms the foundation of the suit is I am the title holder. And my lord, they are disturbing my ingress and egress. Nothing else. Nothing else. My lord, in order to approach DRT within the meaning of any person aggrieved, my lord, I had to, my lord, say, raise a complaint against the secured creditor, que escape taken under 13.4. I am not aggrieved. I say whatever bank has done, my lord, has rightly done. DRT cannot look into the issue as to whether, my lord, he can stop my ingress and ingress till, my lord, the sale notice is not set aside. My lord, the sale is not set aside. So, my lord, 34 has no manner of application.
So per se, the suit is not barred. You filed a suit for declaration of your title and basically confirmation of your possession and all. And you had no knowledge of section 17.2 because that was served on you later. So you were not supposed to know that there was a dispute even regarding that.
Correct. Because my lords have seen, my lord, the order sheet handed over to your lordships. The last order
Not served,
says
not served.
not served. And
That
prior
was
to that suit was instituted,
that
order was passed.
Yes. And even if suppose we take the worst case against you on section 34, if it relates to a matter, because if even in the written statement there is a dispute,
can't be a subject matter
then
before DRT.
It cannot be a bar like 711 bar, order 711, and not a threshold bar.
Yes.
Your suit has to be seen as it is on the plaint.
Yes.
Till the date when the present impugn order was passed.
Bow down to your lordship.
Subsequently, in the suit, they may raise an issue on in their written statement. If that is done, then it may become a dispute in
Too
respect
early
of-
to presume, my lord.
Too early to presume. Very good.
Bajrang, my lord, I am not, my lord, troubling your lordship with any more. Kunta? तो जज साहब देखे नहीं है बजरंग 65 complaints दरकार नहीं. Now, my lord, kindly also take, my lord, paragraph 17 and 24 of the IA, which my learned senior friend have, my lord, relied upon. 17 and 24.
Yes.
My lord, before looking at section, my lord, paragraph 17, if my lords kindly take the trouble to have a look at paragraph 15, where, my lord, they were speaking of the second 13.2. My lord, the date which my learned senior friend has, my lord, given as regards the issuance of the 13.2 is not matching with this date also. My lord, first date was 18th October 2016.
2110. They said 1610.
Yes. This is, my lord, 18th January 2022. My learned senior friend has referred to a date, my lord, of 16th October 2024, if I am not wrong.
Yes.
So, my lord, that was
Was there
third
a
in line.
third notice?
So, my lord, that was third in line.
Maybe.
So, before the second notice also, my lord, the lease had taken place. And now kindly have a look at the abaments in paragraph 15. Thereafter, the defendant number 1 issued another demand notice by recalling the earlier. So, what my lord was, my lord, trying to, my lord was, my lord, contemplating two possible options. My lord, he demolishes, my lord, one possible option. He says,
Para
why
20,
recalling?
Para 20 they say about the 16.
Correct. So, my lord, it is not their case also that, my lord, as if the section first 13 to notice were never there. They say, why recalling? So, it was recalled on the date of issuance of the subsequent notice. That's his own version. The issuance of the said subsequent demand notice was illegal and without jurisdiction. Your petitioner
Oh,
number.
yes, Mr. Banerjee, you have a good case. Para 20, please read it.
I was about to take your lordship to paragraph 20.
You have read it. Don't take us. Without withdrawing. Without withdrawing.
That's their case, which is why in paragraph 15 they say this is illegal. I was about to take your lordship to that. So, Milord, I don't show any further paragraph from
Give
this.
us half a minute.
29
দেখাবো, আবার দেখাবো। এটা তো আজকে জয়দীপ স্যার অ্যাডমিট করে গিয়েছে।
তাহলে
আচ্ছা, আবার
নন টাইটেল
সেটা আরেকটা।
সেটা জাস্ট আরেকটা
Without withdrawing. তিনটে নোটিশ, থার্ড নোটিশটা বলছে উইদাউট উইথড্রয়িং দেয়ার। হ্যাঁ, যদি উইদাউট উইথড্রয়িং না হয় তাহলে ওই ডেট পর্যন্ত ফোর্সে রয়েছে, তাহলে রেট্রোস্পেক্টিভলি ওটা ইয়ে করে যাচ্ছে। বাই কন্ডাক্ট ওটা ওয়েভ করছে ধরে নেওয়া যায়, বাট কিন্তু নোটিশটা ইটসেলফ হয়তো ইস্যুটেড হবে না, কারণ আমি নতুন নোটিশ দিচ্ছি মানে অটোমেটিক ওয়েভ হচ্ছে, কিন্তু স্পেসিফিক্যালি উইথড্র করছি না নোটিশ, নোটিশগুলো ওই দিন পর্যন্ত সাস্টেন ছিল। ইভেন আদারওয়াইজ রেট্রোস্পেক্টিভ হবে কিনা সন্দেহ। Yes, yes.
Milord, then 18, Milord, I just now indicated 18 my lords have seen. Then comes Milord 20.
17 we have seen. 17 and
18. Milord, there was a third. Then comes the fourth.
yes.
Now, kindly Milord turn to paragraph 29.
This is probably a pastime for the bank. What was the bank? Which bank? This is not a
I
bank.
can't Milord make any comment on that.
What is the bank? It's a fact. Question of fact.
Oh, RC. Reliance Capital. Milord, that was the asset reconstruction company. তার আগে ব্যাংকটা কে ছিল?
No, there something Reliance must be. Once Reliance comes in,
Can be
everything will
relied upon. Paragraph 29 then, Milord, their own statement. Your petitioner states that the defendants have deliberately omitted to mention in the said notice the encumbrances of the said properties. The dues of Kolkata Municipal Corporation in respect of those three properties has remained unpaid for a considerable period. KMC, in view of such default, has taken over physical possession. Mr. Chakraborty, Milord, when was appearing before your lordship, Milord, made a submission that Milord KMC never took possession. KMC took possession only of the movable assets because Milord, there was a distress Milord notice. Not Milord, a notice which required an immovable property. Milord, that submission is now.
His precise submission was could not have taken possession. He did not say did not take possession. He said could not have taken possession.
Both.
That
Milord, he
may
said
be,
did not and could
did
not.
not
Both.
also said.
Yes. Now, Milord, did not is Milord belied.
Not is belied.
And could not Milord
make
is
part
not.
into the legal position.
Milord, KMC Act provides for Milord that.
We'll come to the
Yes,
KMC
yes,
Act after this.
sentence.
That will be the last phase of your reply. Bro.
Almost.
So that is the last.
And
remaining.
Milord, that Yadurappa, na ki naam? Eliappa.
Remember the name, will come back in. Yes.
So, my lord, 13 prior 13 to my lord, those point goes.
Yes. Now KMC. That
Now,
handing
my
over
lord,
question.
KMC. Can you my lord have a look at section 221 capital A? Mr. Chakraborty had
KMC,
argued that
KMC.
my lord, may I hand up?
We
May I
done
hand up?
There we have it.
221 capital A. So KMC can also, my lord, take, my lord, attach movable properties, can sell it also. And they have the first charge. It's not in dispute that, my lord, KMC sealed and desealed. So, my lord, that was in exercise of powers under 221 capital A.
The receipt, yes. No, these prerequisites have to be satisfied then. There is nothing on record to show.
My lord, that's for them. And my lord, KMC is not a party. They have not filed any proceeding against KMC saying that, my lord, whatever KMC has done, my lord, was illegal. On the contrary, my lord, the 2001 judgment, which my learned senior friend has cited, my lord, helps us on this, my lord, proposition. Paragraphs 31 and 32 of 2001, volume 6, SCC 512, says that after derequisition, property should be made over to the person who at that point of time, my lord, was entitled to get the possession. Lessee had lost its right, so, my lord, though it was taken from lessee, cannot be given back to the lessee. Paragraph 31, which my learned senior friend has cited. The lease was no more there, lessee had lost right, may place.
31.
31.
Yes.
Further, a person whose lease has expired is still entitled to maintain possessory rights so long as and until he is evicted by due process of law. Various decisions have been cited before this court, but we do not consider them relevant in the matter under consideration. The factual aspect of the matter has to be gone into to make the provisions of law or judicial precedents applicable. The proposition which is noticed above pertains to the possessory right and eviction in accordance with law. The lessee has lost his possessory right and the same stands shifted on to the state. Once, however, the possessory right is transferred or shifted from the lessee and the lease deed stands terminated during this temporary interregnum, when the lessee was deprived of its possession, question of putting back the lessee onto the possession after the expiry of the lease in accordance with the provisions of law does not and cannot arise.
Yes.
In our case, my lord,
This was not terminated.
he ceased to be a title holder.
Who?
My lord, the borrower, from whom, my lord, the possession was taken and the property was sealed.
No, that is not the proposition there. That's circular logic. But cease to be a title holder cannot be relevant consideration here, because the lessee lost his possessory right because
of termination of the lease.
Further, a person whose lease has expired is still entitled to maintain possessory right so long as and until he is evicted by due process of law. So now then that culminates. Once, however, possessory right is transferred or shifted from the lessee and the lease stands terminated. Acha.
Then, my lord, it says the court has to do equity, and in doing so, it has to consider the fact situation of the matter in issue, and it is only thereafter pass certain orders thereof.
But there the lease had expired.
Correct. Here, my lord, the lease is invalid because of, my lord, non-compliance of the mandatory provisions of law. My lord, you have a better case. We have a stronger case. There, my lord, there is a valid lease which expired. Here, my lord, there was no lease even in the eye of law. By reason of non-compliance of 65 capital and also by reason of, my lord, 13.2, my lord, lease, my lord, following 13.2. So there was no valid lease even, at least prima facie. So, my lord, what happened? Bank, my lord, sold it on as is varies basis. Section 14, my lord, was resorted to. My lord, that finds place in the plaint. My lord, I'll take your lordships to the paragraph of the plaint. Bank, my lord, made over possession to me on as is varies basis, meaning they are.
Suppose there was an ordinary transfer to a different owner. Lease, that would be subject to the lease. lessee cannot automatically go because of the transfer of title of the lesser.
My lord, if I can satisfy my lord's conscience that the lease was in breach of the mandates
That's
of
a
the
different
statute.
argument. But this judgment otherwise applies.
Otherwise,
You
could
cannot
have
accept your
applied.
argument that that it has to be handed over to the person who is today
Is entitled
the
to
title
possession.
holder.
My lord, this
You
readily
cannot say
tally
that.
upon.
The entitlement lies still with the lessee unless he is evicted by due process of law.
Provided he is a lawful lessee.
That's not there in the judgment.
not
As per the judgment,
Judgment proceeds on a
judgment
basis.
is squarely against you otherwise. If the other point is not there, that's a different point. But we cannot accept that proposition that as of today, the title has been transferred from the lesser to you, and therefore you are entitled to
But
possession.
my lord, the learned civil court has to see, subject to, of course, correction by lordship, whether there was a my lord lawful lessee or not.
That's a
Time of
different
his time.
argument, as we are saying.
Yes, yes. If there is no lawful lessee, no possessory
Whoever
right.
becomes the owner, that would be subject to the lease.
Provided, yes, my lord, I add to that.
At the
Provided
there is no challenge to the lease deed by anybody. The lesser does not challenge the lease deed. Obviously, the lesser does.
because now, my lord, the sub-lessee has sued the lessee without impleading me in civil court to get the status quo order, which, my lord, they are now, my lord, portraying before your lordship.
So you are there in that.
I'm not there.
You are not a party
No,
to any of these.
no.
Okay. And you say your argument is also that because they are relying on 65A and a judgment citing that, so therefore they have to show
Compliance of
threshold
65A.
that 65. That argument remains.
65A plus 13(2), my lord, preceding lease. Both. Now, my lord, what here, my lord, actually happened, which is, my lord, not in dispute. Property was sold on as is where is basis, sale certificate registered, property, my lord, following section 14, handed over on as is where is basis by none other than the bank. My lord, admitted position in their IA application, my lord, paragraphs 29, 35, 41. They say bank has handed over. And bank had handed over 29, 35, 41 of IA.
What do they say bank has handed?
Yes. Huh?
They say KMC is in possession.
May I just.
That is the point in para 29.
No, take a bullet. Kindly, may not bear with me for a second. Kindly turn to paragraph 41. আমার মার্কটা কোথায় কোথায় যাই হোক ঠিক আছে defendant numbers 1 and 2 have handed over possession. That's their case. And Milo, this is true to their knowledge. Not true to knowledge, no? Their submissions. Belief, information, and submission. That's the case they are running before DRT also.
This is before DRT.
Yes.
This is the IA before DRT.
Yes. The defendant numbers 1 and 2 in violation of the order of status quo. Status quo means the civil courts, city courts order, where bank is possibly also not a party, I do not know, had handed over physical possession of the aforesaid property of the petitioner number 1 to the defendant number 4.
But in para 39, they say this has to be read with para 39.
Correct.
It appears that without first taking physical possession of the property in accordance with provisions, 1 and 2 have wrongfully, illegally handed over physical possession.
Yes. The defendant numbers 1 and 2 have wrongfully and same thing, not same thing.
All right.
So, Milord, on as is where is basis, possession is given, property was sealed. Milord, I paid the taxes. And Milord, I have shown on the last occasion that Milord, they were referring to pay, Milord, alleged payment of Milord property taxes by them by referring to certain documents, calling those documents Milord as property tax receipts, which are Milord property tax dues and demand notices. Should I, my lord, take your lordships back to the document once more?
Property tax notice by
KMC.
no. Please repeat that argument.
My lord, their argument was that, my lord, that they had paid the property tax, and in support of that, my lord, they relied on certain documents, portraying those documents as if those were property tax receipts, which were actually, my lord, notices of demand issued by KMC saying that for decades, property taxes, my lord, are lying payable, not receipts.
Pages.
My lord, page 3, kindly take off the, my lord, affidavit in opposition of the rest.
We won't take. Give us the pages.
Oh, my lord, page 3, clause A
Of
affidavit in opposition of R1, coupled with annexure R1,
page 3, para, clause
small a.
Yes, coupled with
My lord, pages 16 to 18 of that affidavit.
Acha, we'll look into that. This is respond number 5. One.
Borrower.
This is actually shorter than the other one. Yes.
My lord, the sub-lease is, my lord, thickest one. Leases is, my lord, thicker. And my lord, borrowers one.
Obviously. Where the shoe pinches, it will be thicker and thicker. They have grown a callous shell because of the sufferings in your hands.
Man, because of accumulation of wisdom, my lord, with the passage of time. It
Yes,
becomes
actually that. No, not only wisdom, accumulation of developments also in the meantime. 3A. Yes.
3A.
So 3A you see.
In all material times, my lord, this is their
No, where are the photocopies? I mean,
16.
tax receipts they say.
They say receipts, and my lord, the documents they annex are, my lord,
LOI
letter
for
of
unpaid.
intimation,
You place that on the last again.
Yes.
Yes, at the time of drafting, probably this because it's in shaded.
My lord, if one has to draft, my lord, 3 oppositions for the borrower, the lessee, and the sub-lessee, very difficult to reconcile. Very difficult, you know.
Yes. Anyway, we don't take note of that.
No, please do not.
Yes.
Please do not. Now, my lord, ask your time. My lord, so on one hand, my lord, I say that, my lord, this lease is invalid. On the other hand, my lord, I have a third argument also based on, my lord, Aliyappan. Aliyappan clearly says that, my lord, non-title holder.
Now you've got the name correctly.
Yes, my lord. South Indian name, my lord, for me, very difficult to.
You're very racist.
It says, my lord, non-title holder has no locus, my lord, to challenge the modus of giving up possession.
What is the
to a
citation?
title
Which
holder.
one? Which one?
My lord, it's an unreported decision, my lord, we cited.
You cited.
Yes.
Oh, that.
Yes. Non-title holder, my lord, cannot have a locus to question modus of giving possession
Yes,
of
that
the property.
you started with that. Almost started with that.
Yes.
So you've already cited that.
Yes.
In rejoinder, you need not reiterate all your other arguments. So you have met there, Mr. Courts, and
now, my lord, kindly take the plaint once of the stay application, means annexed to the stay application, page 26. 23, my lord, the plaint starts.
No, it opposition.
Mr. Nundi, you are for the middle lesser. Middle. Or lessee, whatever you call it.
The liaison.
The sandwich. Lesser as well as
Not
lessee.
sandwich, my lord, is liaisoning between two.
Matter of perspective.
Yes. My lord, page 26, my lord, paragraph 8.
Of the
Of
application.
my lord, my stay application.
What is this?
My lord, this is part of the plaint.
Oh,
My lord,
yes.
plaint starts at 23.
What are you trying to submit?
That, my lord, I have specifically, my lord, said on oath in the injunction application that, my lord, section 14, under section 14 position was given.
Was taken.
Was given to me. Was taken and given.
That is contradictory with KMC having.
No, my lord, position was given by the bank on as is where is basis.
Where you say symbolic position. You say symbolic
Yes,
position.
yes. and then my lord desealed by
No,
KMC.
you admit the facts are admitted by you. Bank gave symbolic portion under section 14.
If my lords call it symbolic.
No, you call it symbolic.
Kindly turn to my
Not
lord.
us, not us, not us, not us.
Kindly turn to my lord paragraph 8, page 26. That's my lord my avowment before the learned trial court. Consequently filed an fourth line, my lord, at paragraph 8. Consequently filed an application under section 14.
No, this is paragraph
8.
8, yes.
Of the plaint at running page 26.
Yes, consequently, seeking physical possession.
Thereby seeking physical. The said application
Achha,
was allowed and the asset reconstruction company was permitted to take physical possession. Could not because of sealing by KMC.
Oh, symbolic possession was used in their IE.
Page 86, their letter to the police authority.
Somewhere we saw that. That was
Page
placed by
86.
Mr. Kaur.
I'll take your lordship to that also.
The police complaint. Yes, yes, you also did. Yes, yes, you did. You did.
Page 86, fourth
Symbolic
paragraph.
possession, yes, yes.
Now, my lord, kindly turn to.
So you are taking contradictory stands.
No, my lord. I say, my lord, bank has given me possession on as is varies basis. My lord,
page 86.
Kindly turn to page 86 now.
This is your complaint.
Yes.
You filed the suit when? After this date?
Yes, my lord, this is annexed to the plaint.
Oh, that's right.
Yes, I use, my lord, the expression symbolic. Page 80. Page 86, my lord, fourth paragraph.
Your sales certificate says as is where is. Your complaint says symbolic possession, but in your plaint you go and say physical.
No, plaint I say, my lord, possession was given.
Physical.
Right.
That paragraph. Para 8, page 26.
Just check.
The said application under 14.
Permitted take physical possession and then possession was given. I don't say physical possession.
RARCL is who?
Asset reconstruction company.
They were permitted to take physical
possession by section 14 could not because of sealing by KMC who was having the first charge. And then I say the said application was allowed. Asset reconstruction company was permitted to take physical possession. I have not said the asset reconstruction company gave me physical.
In your case, the complaint and the this application
that after
was drafted by different people.
After desealing, my lord, I got the possession. That's my case.
Just one interjection, my lord. Para 12, last line, my lord. They says possessed.
This is my consistent case. The section 14 possession with the lock and key, with the padlock, my lord, on the door, and then, my lord, opened by KMC after payment, I get the physical possession.
So that symbolic possession in the complaint is out of place. I mean, one stray word. Oh no, you say symbolic possession of the suit. You all along say that.
I all along say.
Yes, sir. Right, yes. So that is consistent with paragraph 8.
My stand is consistent. 8, 12, everywhere. I said section 14 allowed physical possession. I don't say for a while that I got the physical possession.
Section 14 contemplates permitting you to take physical possession.
No, section 14 contemplates, my lord, the police will assist me, my lord, to have the physical possession.
Section 14 is exclusively reserved for taking physical possession.
Correct.
Isn't it?
Yes.
So you say the under section 14 was allowed and you were and the
then, my lord, when police went, there was
permitted to take physical possession.
Correct.
But section 14 magistrate has no power to permit.
The language, my lord.
No, language. You're relying on this language. You are saying you are not given physical possession under section 14. You say you are permitted to take physical possession under section
through
14.
Police assistance. My lord, this is for the magistrate to take possession through police and give it to me.
Magistrate never took possession as per your plaint.
No, could not because of first charge of KMC.
Whatever reason.
Yes.
Section 14 magistrate can only take possession. Cannot permit anyone. Magistrate is nobody to give permission. Permission in the sense can direct possession to be taken with police help.
Correct.
Magistrate has to ensure that physical possession is handed over to the authorized officer of the bank and then whatever the bank does. But here this permission under section 14 is neither here nor there. Fact then remains that possession was not taken under section 14, Mr. Banerjee.
Physical possession was not taken under
14 contemplates only physical possession, no symbolic possession.
True. So possession was not taken under section 14.
See, if possession was not taken under section 14, is the possession taking of the possession valid in law? Under SARFAESI Act. That is a question raised by them, not
Milord,
that we are
for
raising.
for DRT to decide. Firstly, secondly, Milord, non-title holder, Milord cannot ask
Civil
this.
court has to decide prima facie before granting any injunction order to you.
Whether I am
Whether
in,
you are trying to protect
whether I am in
notice-
lawful possession or not, settled possession or not. What is meant by settled possession?
Yes, lawfulness, one of the
Settled possession.
components of not settled only, lawful possession also. An unlawful
That is-
occupier cannot
that is-
take the assistance, take the seal of court, cannot take the blessings of the court. So Section 14 violation is also, that is the only mode provided in law in a SARFAESI sale. Now, this is also a tough question which you have to face, because if you did not
No, facing temporary stage.
no here to get injunction,
Very well.
then your
I satisfy
the
my
lawfulness of your possession, Mr. Banerjee, the lawfulness of your possession is also vitiated by contravention of Section 14. That is the only mode in which you can take possession, and the bank can take possession and give it to you.
But I have threefold answers to that.
Threefold answers to that.
Yes.
What are the threefolds?
I tell you.
Yes.
Section 14, Milord, contemplates physical possession only. Section 14 order is passed. Milord, I don't have the order, but
No.
yes.
We go by your plaint case.
Correct.
At the ad interim
So,
stage,
Milord,
we go by your plaint.
Section 14, Milord, there was, Milord, on affidavit, I ran a case that, Milord, there was a direction for taking physical possession, which could not be taken because of the first charge under the KMC Act enjoyed by KMC. Milord, there were dues. Milord, I paid the dues, and the property was given over to the title holder at that material point of time. A non-title holder cannot question this, Milord, modus of giving possession to the title holder by our authority. That's my simple case.
Could you get this injunction in the first place? Is your possession lawful?
Milord, may I show one decision, cite one decision, what is meant by settled possession? Milord, which is to be protected by injunction.
This is a second judgment which you will have a right to answer. Because this is a point raised by you. In reply and there in rejoinder they're entitled to citation.
No, no,
I mean, and we are speaking to both of you, Mr. Nandi and
settled possession.
Primarily Mr. Mundal, because
One
this
done,
point was taken by Mr. Kaur also.
কতগুলো করে দিয়েছে
Yes.
7, 8, paragraph 7, 8, and 9.
Para 9 answers the first sentence.
Here, Milord, I had the title.
Yes.
So this is to be protected. Read with, Milord, of course, Eliappa. ওইটা এলো রে খোঁজবার করার চেষ্টা করছি আমার প্লেন কেসে কবে ডিস্টার্ব করবো আর কবে ডিস্টার্ব করলো প্লেন কেস অনুযায়ী পড়িয়ে ফেলেছি
Yes.
And 13, order 39, rule 1 says, Milord, it's on affidavit. At that interim stage, Milord, either by
We
documents
are
or
going only by the plaint case.
plaint case. Yes.
Plaint and injunction.
Yes.
Because in the plaint, we are going only by the plaint averments for the timing for this point.
So, my lord,
Plaintiff
September.
stated section 14 permitted you and you took possession through the KMC.
Now, September, my lord, I got the possession, desealing. December, they start, my lord, 3 months I was there. So, my lord, this Rame Gaura decision says, my lord, for a substantive period, I have been there.
3 months is not a substantive period. That was for a trespasser who was there for long. Rightful owner, against rightful owner, trespasser can also get an
Again,
injunction.
a
That
title
has been
holder.
diluted in subsequent judgments. Trespasser whether can get an injunction.
Subject to my limitation.
But still, you are not a trespasser.
Yes, I have a title.
I mean, if you have a title, not trespasser in that sense. Although you trespass into the property, even if you trespass into the property, there may be a situation a person verb and noun don't coincide.
Now, my lord, the second judgment which, my lord, my learned friend now has a right, my lord, to reply, which says that, my lord,
no, we will not take so many judgments.
My lord, which says that, my lord, bank can, my lord, take resort to section 14 even after, my lord, sell.
That you have cited.
My lord, I did not make it over.
Yes, yes. These are the only two judgments you have cited.
Yes, yes. Paragraphs 46, 46, 7, 44 to 48. ওই যেটা বললাম দাদা 18, 15, 99 paragraphs 44 to 48.
Yes. But here it is not such a scenario. Here, this says that even after confirmation of the sale, possession can be taken by the bank. By the bank, or it's silent on that. Let us see.
So, my lord, section 14 lies even after sale.
Lies whether the creditor could maintain an application. That has been held in the affirmative. The creditor could.
The question that was posed to the Honorable Supreme Court was whether, my lord, after sale, my lord, the secured creditor loses its status as secured creditor or not. It says, my lord, no, because secured creditor has a duty to make over physical possession. Till such duty is, my lord, performed, he remains a secured creditor.
All right.
সেটা তো DRT তে হবে।
Yes, any answer to this?
May I? We will come back with written notes of argument and kindly give us 5 minutes time so that we can answer to this to particular judgment only.
On the prayer, hearing is substantially concluded. Full stop. In order to permit the respondents to meet MWT, the proposition relied on by the appellant in their rejoinder reply by way of citing two judgments, comma, let the matter stand postponed till July 15, 20, today we are on 9th, yes.
My lord.
July 15, 2026. Full stop. The learned counsel for the parties, learned counsel for the appellants and the respondent numbers 1 to 3 are requested to file their written notes of arguments on the returnable date. Full stop. In view of the respondent number 5 having already filed its written notes, comma, no further direction is passed in respect of the said respondent. ওনার written notes of arguments already আছে এখানেই বোধহয় আছে সাইটে আচ্ছা এইটা আপনাদের এটা to be mentioned দিয়ে দিন will appear as to be mentioned, just make a very brief reply to that.
I shall convey that to Mr. Kaur.
If the reply, if Mr. Nondi, your reply is similar to Mr. Kaur's, then just give, then just adopt it. Yes. Thank you. এটা ঢুকবে এগুলো ঢুকবে সাইটেশনসে ঢুকবে হ্যাঁ
Thank you. Great.
Thank you. Need.
May it please the Lord.
Yes.
One of the writ petitioner is the appellant here.
Yes.
My lord, this is a body corporate, a state, my lord, under the extant municipal laws. My lord, the allegation against
Parthovodam Rai is appearing for the respondent.
Online.
He's coming. I'm praying.
Coming. Yes. Take your seats. Yes. Yes.
The allegations against me, my lord, that But I being a municipal body,
Yes.
my lord, have encroached, my lord, also a government land, where my lord a PWD land, and constructed, my lord, a toilet over there. Now, my lord, this is the moot point. Now, my lord, I have, my lord, issues that I would be placing before lordship. My lord, there are, my lord, 4 to 5 aspects, my lord.
So, what is the urgency in the matter? Why did it
urgency is, my lord, that, my lord, on the basis of the order passed by the learned single judge,
Yes.
affirming the order passed by the DM in appeal, my lord, they have, my lord, are sending, my lord, their bulldozer, etc. My lord, it's a public toilet along with a rest house constructed at a local heart for the purpose of villages, for the public purpose, for public welfare for last 40 years. Now, my lord, we are at such a stage, my lord, at any moment, my lord, the PWD.
This was admitted previously, formally admitted.
My lord, it has not been admitted, but there is an order by the vacation bench which, my lord, granted me liberty to press for an interim order and also to use a supplementary affidavit. That
Prepared a supplementary.
yes, we have prepared the supplementary.
Full-fledged hearing of the appeal. Other appeals are there.
Yes,
so
my
we'll
lord. Only,
consider.
my lord, it may be, my
What
lord,
is
taken
the best case you have?
My lord, I have
the order.
the best case, my lord, that the order, my lord, which is under challenge. My lord, my point is that the West Bengal Highways Act, my lord, parts say do not apply. My lord, the Government Buildings Act will prevail over. My lord, there is admittedly, my lord, our permission was granted. Now, my lord, there are several plots that have been there, my lord, in respect of which, my lord, in 1988, the then Haldia notified authority, my lord, pressed for permission, my lord, to use those lands for the purpose of public welfare. PWD expressly stated that they do not need such roads and or the plots for their own road expansions, and those may be given. There may be missing of 1 or 2 plots, but all the plots are there, including the subject plots. And the permission was given for the purpose of development of the plot. Now, only the
to produce anything regarding that permission, para 28 of the judgment.
Exactly. That will be the first point, my lord.
That's a good ground.
No, my lord, that is the there, my lord. The
permission was.
No, the permission was already there.
That's your case. You could not produce any document to show that.
Well, the document which was produced before the learned judge, well, the held that such, well, the document could not per se construe as a permission. Where, my lord, in the contrary, that record itself says that only, my lord, for the purpose of transferring the land in my favor, that would be in process. Now, Malan, my point is development of the land and transferring of the land in my favor are two different aspects. I was permitted to develop the property. I was permitted to construct the property or constructed over the land. The transfer is still pending, and I have also a substantial document.
The case is premised on that permission. This is a highway property otherwise.
Well, this is a PWD property. This is a state property. I am also a unit of state. Now, my lord, my lord, there was a previous order by this division bench which passed before, my lord, 10-2 proceeding, whereby, my lord, this honorable division bench, while directing the authority to initiate the proceeding, there is a recording that, my lord, that admittedly, my lord, quote unquote, admittedly, there are encroachments. The learned single judge held that such order attained finality. With the deepest of respect, my lord, such recording, my lord, were premature before initiation of a proceeding, before adjudication of the lease by the authority for which, my lord, it is conferred under the statute. Unless, my lord, those authority have found and adjudicated the lease, my lord, it cannot
finding was in connection with the writ petition.
Sorry, my lord?
Those findings which has attained finality.
Exactly, before 10-2.
Yes, those were in respect of a writ court's order.
Writ court's order. And, my lord, it cannot construe either as an order or a decree considering determination of a lease in terms of section 2 of CPC. Is neither forms any part of a judgment. That cannot be something interlocutory. That, like, my lord, in a section 9 in the, my lord, arbitration in view of the Arbitration Act. And that is a principal point the learned judge held, that such order attained finality. If that be so, there could not be any process for 10-2 followed by 10-3 and 10-4. And that is my also point, Miller. The authority proceeded on the basis this court has held there is an encroachment. And that was only a formality, merely a process and an ornamental tool just to conclude and give an effect of this honorable court's order.
If it's admittedly a PWD land and you are not the PWD, You have to show some right on the property.
I have.
That
I
you rely on the permission for that.
Exactly.
Let us see that document first.
Exactly. This is by way of a supplementary affidavit, my lord. This was already
No,
there.
no copy given to them.
No, copy given to them. Well, they have
What do you? The complainant?
complained.
You're a busybody.
Well, the complaint says that, well, complaint doesn't say about this.
You have photocopy now, Mr. Rai? Look, go through that. You can do that.
Well,
Where is
complaint.
that permission?
Yes. Well,
Page 6.
Page 6. The complaint, well, the original complaint by the busybody.
Complaint we are not. No, we have the right to call him busybody, not you.
Well, what I say, they say that the construction, Millard, blocks the
Let us come to that permission.
Please, Millard. Millard kindly comes to Millard. This first,
because we have become very busy bodies after so many pendency of so many.
Millard, I
so let us
appreciate Millard.
Yes.
Millard, this first document, Millard, is a handwritten copy.
Handwritten. What's that?
Well, previous to that,
page 5.
Page 5. Yes. This is a handwritten copy. The proposal for transfer of 1336.5 square meter of land in Dag number 144, 145, 146, 149, and 779 under Mouja Durgachok.
And start the construction work.
Exactly. Now, Millard, in the in the subject, all the plots, including Miller, Lordship would find that Dag number 1452 under Mouja Shutahata.
That is
now,
the present subject.
Present subject. Now, in the body, I must be fair, Miller, and I have to be, ought to be, Miller. In the body,
as an exception, be fair. Yes.
Well, yes, kindly comes to the body of the letter also. In the body of the letter, all Dags are mentioned. There's the previous. Except that. Now, this is by way of a slip or omission. Now, kindly see, Miller, the copy forwarded. See, Miller, this is very important. Copy forwarded to Executive Engineer, Highway Division for his kind information necessary action. The notified authority is pressing hard to construct their administrative building on the aforesaid plots. Kindly see aforesaid plots. For their interest of the public service, and accordingly, they made several correspondence and pursued verbally. As we do not have any objection to hand over the aforesaid land to the Haldia notified area authority, and as there is no provision for the future considering of the road, the notified area authority can go ahead with the case in anticipation of the approval. Now, Miller kindly turns to the next page. This is a type copy. Then the executive engineer replied. Again, in subject, Miller, kindly see this Dag number 1450 was mentioned. In response to his letter, it was an interse. The reference, this is to inform that land in question may be handed over to the Haldia notified authority after fulfillment of all formalities. Only, Miller, handing over is all that remains. Then, Miller, it was copy forwarded. This has reference to the assistant engineer Haldia such and such in reference to his memo dated 1988. Is a 40 years old, Miller, a structure. Now, Miller, kindly also look into, Miller, one document in my lord's brief. At Miller in the stay application, my lord may kindly look into the minute held by the district magistrate in presence of this PWD and Haldia municipality and others, the resolution at page 74. My lord have found, my lord, page 74. The decision taken.
Yes.
The district magistrate had taken decision, my lord. See, my lord, the list of attendees enclosed. Lordship has found, my lord, top left side.
Top left.
Page 74.
74.
74.
List of attendees. Yes. Enclosed.
Exactly. Now, my lord, first comes to that list, page 78. Is this not, my lord, very happily readable, my lord? I apologize. Kindly see, my lord, from serial number 12 onwards, 12, 13, 14, 15, 16, all are PWD. Along, my lord, our presence are also there from the municipality. Now, my lord, kindly turns to page 76.
Yes.
Serial number 13. NOC for PWD road. Lordship has found, my lord.
Hmm.
The executive engineer PWD Purbo Medinipur is requested to look into the matter for providing NOC to Haldia municipality for roadside level operations such as beautification along with SH4 Mecheda Durga Chowk road from this Jayanti Bhavan to Manjushri More under Green Chowk City Mission.
Also see clause 18.
Exactly. This transfer of vested land to the Haldia municipality. So, my lord, this is only
The last document which you produced.
my lord, there are other documents, my lord.
After this,
Even after this 23 also, the supplementary affidavit, my lord, I have been repeatedly pursuing that please kindly, my lord, follow up this process of transfer. This is also a part of record, my lord. Kindly transfer 24 even, my lord. Page 8, 9, 10. Prima facie, my lord, I have something on my favor. Number one. So, my lord, it cannot be at the very blush, my lord, cannot
this
be.
was the previous read court orders which were relied on by the
Exactly. My lord, please
where you
stand
are,
to, please, my lord.
held to be.
Please, absolutely, absolutely. Please, my lord, previous to the single judge's order. Single judge's order, then, my lord, division bench
Single
order.
judge relied on certain, says that it attained finality.
Yes, single attend relied on a division bench which passed on a single judge's order. The single judge's order was
So the previous single judge's order.
exact. Single judge's order passed on their representation that I made complaint, but PWD is not taking. Yes, please, my lord. Kindly turns to page 82.
Yes, you have something to add here. Something to add here.
My lord, may I submit only one thing?
You're conceding to the
State.
You're conceding to the writ petition. Short of that, you need not submit anything.
Well, so for the point of permission is concerned, only one point. Permission is concerned. My lord, their stay application in page 8 and 9, para 7. They say it, that is LR plot number 752/1452 Batadak in Moja Shutahata. My lord, where is that in supplementary affidavit? Where is that in impure? Nowhere it is present. That dag and that moja, it is in Durga Chowk, and all the dag numbers are different.
That's probably a copy paste error.
No. That is the point. That is the impugned order. Categorically impugned order said so. Para 18 of that impugned order.
The documents cited by Mr. Post.
It is also not there. It is not there.
Produced. It appears that that plot number was not there. You were logically.
These documents which are relied on by Mr. Post, they speak of a different plot.
Yes. Not only different plot, different moja also.
The writ petition also.
May I submit? Kindly come to their stay application. Page 8 and 9, para 7.
Paragraph 8 is subject to question of taking leave of my lord.
My lord, in order to assist your lordship, kindly turns to my lord 10 to order.
I'll not utter a single word.
My lord, before to that, kindly turns to 10 to order. My lord, which would say, my lord, which plots are in issue. My lord, kindly turns to my lord 10 to order at page 91. My lord, kindly turns to my lord page 120.
Well, let them complete with this. Come back to you. 120, yes. This is the executive engineer's order. Page 1, 2,
My lord, kindly turns to page 123.
First to make up your mind as to which page.
My lord, since my lord, there's a dispute with
123, yes, we have there.
Dispute with regard to the plot number.
Understood.
Yes, kindly, my lord, kindly turns to my lord.
We have turned to page 123.
Second paragraph.
We are there. Yes.
Middle portion, plot number 751 of by 142, Moja Shutahata.
Yes.
But those plots are independent 1452.
No, this is 751 is a part of 1452. Part of that.
One second. Dag number 1452 is the subject matter of all those communications.
Yes. Is a 751 is a 751 by 1452 is a bata dag of this.
Bata dag is the relevant dag.
At that point of time, it was only 1452.
Then it would have been 1452 by something.
By some.
By something.
It's the
No,
reverse.
no.
The denominator would have been different.
But
No,
140 page.
Millet, it has come like Millet on the.
You have uttered your single word. Please take your seat. The state may utter other words. Yes.
Millet, the further it would appear, Millet, at page 126, the SDM's order is 751/1452. And my instruction is very specific. This is the same plot.
Your instruction won't do. How do you go by your instructions? You have to go by the documents.
Millet,
Read
exactly.
by the documents.
Millet, this is Millet subsequently has become Millet 751/145.
Where do we find that? It's a different plot. Plot number 1452 has been referred to in all these communications. Plot number 1452 under Moses Sutahata. The date is 2020. When did it become a butter plot? We could have understood if the original plot was 751.
No.
And then there were butter plots, 751 by something. The right hand side figure is not the determinant.
I understand, my lord.
145
different plot, Mr.
My lord, this is my lord what my lord,
May I assist your lordship regarding that point? There is the impugned order.
Yes.
My lord, para 18. Impugned order, my lord, categorically dealt with this point. Para 18. My lord, I am reading for your lordship. Mr. Basu Lanet, senior advocate or the petitioner would strenuously contend that the petitioner made construction on the land in Dag number 1452 with the permission of the authorities of the Public Works Roads Department. And in support of such contention, he placed strong reliance on the memo dated 18 November 1988. That is the memo.
No, this is better. The Dag number 1452 was not mentioned in the body. But there he may have an arguable case whether it was mentioned in the caption, subsequently also in the communications department.
Just 2 or 3 lines thereafter. After going through
But,
the memo dated.
Yes,
such and such,
understood.
It is evident that permission was granted to make a construction on ... square meter of land in Dag number such and such.
Not either in 1452 or 751.
My lord, kindly see the last 3 sentences. My lord, the learned judge held, but no permission either in respect of Dag number 1452 or 751/1452. This is my point, my lord. So this is, my lord, and my lord, so far as, my lord, the government buildings, before that, my lord wanted to see the order of the single judge, kindly comes to, my lord, page 82.
1 minute. The present writ petition was filed by you in respect of what plot? 751/1452. So that's a different plot from 1452.
No, same plot.
Bata plot, part of it may be a part of 751.
My lord, even
not a part of 1452.
No, my lord, even in the opposition used by the state, before the learned judge.
This is in the numerator of the fraction of the Bata plot. The one on top, isn't that the determinant of the parent plot?
No, my lord, so far as this particular...
Suppose a plot is initially plot number 100, doesn't it become 100/1, 100/2 or something like that?
Ought to be.
It's the reverse you are saying. Here it's 751/1452. Apparently indicating that 751 parent plot was broken up into different Bata plots.
But
it's not 1452 by something.
My lord, I appreciate...
So the denominator does not determine the parent plot.
Please, my lord. Now, my lord, here, my lord, this is not even a case of the state before the learned single judge.
Forget the case of the state.
State has even said in their opposition.
You have produced certain documents. Let us take your best case, Mr. Bose, that there was a permission regarding plot number 1452. First of all, there is no averment anywhere in your pleadings that has become this Bata plot. 1. Secondly, under normal ordinary course of business, 1452, if that is subdivided into parts, that becomes 1452 by something, not something by 1452. Thirdly, 2020 we find these permissions, the last document of yours, 2020 or something like that.
There even 1452 is mentioned.
What happened in between to make it?
There even 1452.
There was no further revision of records of rights in the
There
meantime.
even 1452. Malad, this what is there, Malad. But
No,
Malad, I have other points, Malad. Malad, in so far as the
permission goes, what remains?
Malad, in so far as the Government Buildings Act, Malad, if I say, Malad,
If it's a highway property, it's taken by the highways. Highway Act governs.
Malad, whether the Highways Act would at all govern, that would be also a question to decide. If Malad, the Government Buildings Act 1899 will take over all the place. And here, Millard,
you say that overrides Highways Act.
Well, there is a central act that says, Millard, it starts with a non-obstante clause. No act will apply. And Millard, I did not commit any illegality. It may be an irregularity at best. At best, it may be an irregularity.
What is an irregularity?
Irregularity to the extent, Millard, that in black and white, I may not have obtained till date any permission from a state to a state.
Not in black and white, in any shades of the rainbow, you have not got any color.
If your lordship looks into the West Bengal, the Government Buildings Act, just kindly comes to section 3.
Yes.
Exemption of certain buildings from such and such, nothing contained in any law or enactment for the time being in force to regulate the erection, re-erection, construction, alteration or maintenance of the building within the limits of any municipality shall apply to any building used or required for the public service or for any public purpose, which is the property or in the occupation of the government, or which is to be erected on land which is the property or in the occupation of the government, provided that where the erection, re-erection, construction or material, structural or alteration of any such building as aforesaid, not being a building connected with such and such, this is for the purpose of defense. Now, kindly turns to the affidavit used by the state
But Mr. Bose, nothing contained in any other law or enactment for the time being in force. That other law is to regulate the erection, re-erection, construction, alteration or maintenance of buildings within the limit of the municipality. How is that pertinent in respect of a Highways Act? Highways Act is not for the maintenance of any building. See, the non-obstante clause exclude the operation of any law or enactment in force. That law is to regulate the erection, re-erection, construction, alteration or maintenance of buildings. So it's to exclude buildings required for these public services from the rigors of the building regulations and all those things. Highways Act operates on a different sphere altogether. It's not an act relating to erection, re-erection of a building.
Millard, kindly also read Millard in between the lines, Millard.
Between the lines is only white space. This is not the constitution, sorry.
Millard, it also says of construction for the public purpose on the government land. The PWD land is also a government.
Yes, for public purpose, but what is excluded?
The application of
PWD is not requiring it for public purpose. You are a different entity altogether. You are an autonomous body, Mr. Bose. Under Article 12, you may come under the purview of state. That is for the courts to invoke writ jurisdiction. But that legal fiction does not entitle you to claim that you are the state as I mean, you and the PWD are the same authority.
Millard, I am not claiming, Millard, that I being a state, I can do anything.
Yes, no, not anything. You and PWD cannot smudge the lines in between.
Millard,
PWD is a separate autonomous body. You are a separate autonomous body.
Millard, I am a separate autonomous body.
This act is not applicable per se. Does not exclude Highways Act.
Millard, it may be read, Millard, along with the Highways Act.
Yes,
now,
yes.
Millard, it may be read along with the Highways Act, and Millard, in the opposition, even Millard kindly turns to their opposition.
Suppose 2 points on permission. We are not satisfied because of the documents you are relying on themselves. They don't speak about any bata plot of 1452 also. You are now asserting your rights in respect of a bata plot of parent plot 751, not 1452. It's not the other way around.
Millard kindly turns
No
to
permission. Permission was there only.
Millard kindly turns to page Millard 131.
So they have taken out a proceeding under section 10 of the Highways Act, and that culminated in an order.
Millard, this particular
But writ court is only to see whether there is any procedural irregularity, not the merits of the.
Yes, Millard, so far the
finding.
procedural irregularity is concerned, none of the documents were at all looked into by.
This is all the documents you look. What
no,
are you
looked
saying?
into by the authority. The authority
Writ
entirely.
court has looked into and said that this cannot make a difference.
The authority entirely proceeded on the basis of High Court's order and considering the fact, Millard, it attains finality. And that is what Millard, the learned single judge has also
When
held.
those did not attain finality, we suppose we are giving a go-by to that. Otherwise also, it has been held by a competent authority under the Highways Act that this belongs to the PWD, you have illegally encroached. And an order has been passed for your removal. Your defense to that was permission. Permission has not been established. We will refer to these documents and say this does not speak about any permission relating to 751. No, Mr.
Now, Millard,
kindly,
Millard,
court appeal scope is in any event limited. We don't find any illegality in the order at all.
Millard, kindly, Millard, for the time being, Millard, kindly give me 2 more minutes, Millard. Kindly comes to page 131. And I would also like to show one judgment, Millard, that even there is some infraction. But if it is for the public purpose, for the welfare of the state, Millard, that is also.
Highway is not for the welfare of the state.
Millard, Highway has expressly stated that I don't require the plot. And Millard, in the meeting also, I have shown Millard the 2020 meeting. The PWD, Millard, the personnel were present.
Page 131, yes.
131 kindly turns to Millard. It is submitted that as per the provisions of the Government Buildings Act, there is an exemption to the government authority for construction of any building as per provision of section 3.
They have argued all.
But this is
also,
but this is also the stand of the state. And there was nothing otherwise that the 751/1.
The stand of the state, this is a quotation of the section.
Well, there is
the stand of the state still remains the same.
Well, there is also no such averment. Also similar subpara I that this 175142 was not at any point of time was a part of memo which was issued in 1988. Or this is not amongst the concerned plots where I was permitted.
No, they have adjudicated on this issue. The authority has adjudicated under 10.4. And then come to the conclusion that you are in unauthorized. That is independent of any previous fine.
Only to the extent that there is an order of High Court. Kindly comes to the order, Millard. Kindly comes to the 10.2 order at page 120. There was even no finding.
Let us see that.
All Millard, the executive engineer, Millard, the SDO and DM all proceeded on the basis of this honorable court's order. Kindly comes to 120. See, Millard, this hearing in compliance of Justice such and such, Millard, of this order, the matter was taken upon such and such. Petitioner Shukdev Bera is present, such and such. Then Millard is present. Then Millard, the Shukdev Bera alleged that there is a construction of such and such. He demanded the chairman of the municipality that there is a small, now it has been remodified in the same place for public interest, but no prior permission from the concerned department is taken. He also said that the ingress is not obstructed.
It is initiation of the proceeding.
The issue was that his ingress and egress, Millard, was obstructed. Then
come to page 124. That was the initiation of the
Please, Millard. Yes.
Read that. Case was taken for hearing.
Petitioner, Millard, this is Millard by the SDO on 10.3 proceeding. He is asked to clarify whether such and such belongs to development department, so whether this is a government road and satisfy the provision.
The report was sought, hearing was given. Let us see the conclusion.
Yes. Now, Millard, kindly turns to the order. Millard, this order, my lord, would be pleased to find my lord, SDM
126
126.
or after that? No, 126.
My lord, yes, my lord, 126.
Yes.
Petitioner and de facto present, when an opposite party was absent, opposite party prayer was such and such, was not able to submit any valid documents for their claim during the entire period of proceeding. The case record is taken up. It appears that assistant engineer such and such to the chairman with a direction to remove the unauthorized encroachment that the paper my lord has seen, peruse all the documents, BLO report, considering the fact it appears that there is an unauthorized construction on plot number such and such, Sutahuti in front of Riot plot number 751 and 752. Hence, in terms of 10.3, I SDM such and such do hereby authorize assistant engineer to remove. And my lord, 10.2 order, my lord, only say the last page. If a lordship see, my lord, there is no independent finding.
Where is that? What page?
My lord, at 120 and 121.
Yes, those you have placed.
My lord, heard all parties under the circumstances and considering all aspect and prospect. The aspect and prospect only allegations, and my lord, the order passed by this honorable court. Now, my lord, the DM's order in appeal. My lord, that my lord would be pleased to find, my lord, at page 95. There was a previous effort by the DM, my lord, just to see whether ingress and egress, what was the actual, my lord, germen from the complaint being obstructed or not. The petitioner again, Shukdev Bera, came to this court and say that ingress and egress, that issue cannot be a matter of, my lord, under the Highways Act, though that should not be looked into. And my lord, he obtained an order. He only then says, my lord, it's only to see whether, my lord, there is a construction with permission or without permission. Now, my lord, this DM order, my lord will be pleased to find at page 95. My lord, the case is taken up for hearing. The appellant is present on behalf of the state. These assistant engineers are present in the hearing and counsel attendance. In the meantime, the High Court has directed to pass a reading and reason and speaking order, affording opportunity of hearing to the parties in terms of the such and such. As per report of BLRO, it appears that plot number 751 and 752 of Mouja, Sutahata such and plot number 751/1452, classification Noyanjoli, measuring 59 decimal, belongs to Development Department. There is a shul of toilet and drain over 751 or 152, and the petitioner encroaches. So he also encroaches over the plot such and such. As per the report and hand sketch map, it has been seen that there are encroachment of the government plot such and such. The assistant engineer wrote such and such stated that Sulabh County is constructed on plot number such and such without NOC. There is NOC, my lord, I was talking, my lord, that at the DM meeting, where DM also requested, my lord, please provide NOC. After hearing all parties such and record such and such, the SDM order is upheld. Nothing concerned with regard to this is the same person DM. And this was essentially after the meeting was held in 2020. I have been repeatedly pursuing since 1988.
And the division bench order is also very clear cut. 86 to 89.
Well, that has been, with deepest of respect, is something a premature matter. There's a before 10-2 proceeding.
That is attained finally.
No, how could it be? With the deepest of respect, that could not be an adjudication of a lease. The authority was directed.
The observation is it is admitted that the municipal authority had made construction over the land
this
of the
is something,
please let us finish.
I'm grateful.
Page
Please,
88. Please come to page 88.
Please, my lord.
Second last paragraph. We're not gossiping. We're pointing out certain paragraphs. You
Please, my lord, please.
It is admitted that the municipal authority had made construction over the land of the PWD without the permission of the PWD. Illegal construction in such and such.
Please, my lord.
Now, this is an order of a division bench of this court. We cannot brush it aside. You may say this is not under section 10. Yes, agreed. But then, admittedly, you are fighting for this plot, 791 by something, 1452. What right have you shown on the plot? Your case is based on permission. That permission we don't find. Learned single judge held it could not find. Let us forget the previous chapters. Admittedly, you are fighting. You have this Sulabh complex is on this 700 something by 1452. You are in occupation of that. That's admittedly PWD land. You admit that by relying on the permissions.
Please, madam.
No permission is there. So forgetting everything previous, How was the learned trial judge wrong? You did not, you failed to prove any permission.
But even on otherwise, with the deepest of respect, this can at least be considered and looked into. Millard, a process of seeking permission, Millard is all along there, Millard.
No.
Since 1988. And Millard, here, Millard, this is an admitted fact, Millard. This construction is lying over in front of the PW building, Millard, for last 40 years. It is for the public welfare, for the public purpose, Millard, constructed, Millard, in the
The present challenge has been
and may I
preferred.
also refer to a judgment, Millard, if Lordship.
Mr. Bose will look into the judgments, but will impose costs on you because you're wasting the court's time. We'll come back after recess. We'll continue.
Earlier already cost imposed.
We'll increase that. What is the earlier cost?
They prepared a review against this division bench
Millard, on
judgment.
the basis of
What was the cost there?
20,000.
We'll calculate.
Millard, kindly pass order.
There is possibility that
No, we'll hear it.
Millard, kindly pass.
Yes.
there is possibility that in the second half the court may not. There may be a resolution. We're expecting that.
If there's a resolution, we'll see.
The only thing is that
We'll continue if there's urgency. If someone does matters, we'll hear.
Oh.
If someone does matters, we'll hear.
Millard, kindly pass order.
No.
We won't pass order, Millard. Millard, I only tried.
You're already suffering from 20,000. We won't increase that. We'll hear you on the judgment.
Millard, I only tried, Millard, that.
We'll hear you on the judgment. After the recess, we'll continue.
No, Millard, kindly dispose.
Yes, cite it. Yes, cite the judgment.
My lord, this is all, my lord.
No, you are citing a judgment. Cite it.
My lord, I was about to
Please cite it. Don't waste time.
My lord, 2016 volume 12.
Give us copies.
Yes. P42.
Yes.
Only for a limited context, my lord, that
yes,
being a welfare state, if something, even if it's done, my lord, there was a case, my lord, where the compassionate appointment was given.
Yes.
My lord, somehow, my lord, contrary to the rules, my lord, considering the plight of a family. And ultimately, my lord, when the matter was challenged after 15 years, and my lord, went up to Supreme Court considered that.
Which paragraph?
My lord, may kindly turns to, my lord, paragraph 11 to 14 and 18. My lord, 11 to 14 and 15. I only beseech, my lord, that, and my lord, one last request.
Yes.
That since, my lord, my process for transfer of land, maybe, my lord, there are some mistakes. My lord, admittedly, my lord, I made also mistakes, my lord. Even in the recess, I specifically inquired what your lordship had fallen, that it could be understood that something comes as a part of 751 or part of a 1452. But 751 is really missing. Now, my lord, I was told that unfortunately, my lord, since 1988, well, even in 1988, there was no independent 1452. It was all along 751 by 1452. Now, my lord, what is there is there. My lord, I said, my lord, that I tried my best, my lord, up to my limited acumen, my lord, that only to save this thing, my lord, is nothing of a personal interest. At least, my lord, the PWD may be directed, my lord, or requested at least to consider this aspect and, my lord, hold their process for a limited time to reconsider that, my lord, whether, my lord, this could at all, my lord, be maintained. Because the complaint was all along that it obstruct ingress and egress. But the moment while DM conducted an inquiry that whether it at all, well, obstructed ingress and egress, and when found a report that it does not has a cause to that effect, then he again came to by a writ petition, and that order I have also annexed, well, before the learned single judge, whereby he says that under the Highways Act, that cannot be an issue to be looked into. But the complaint itself, my lord, was that it obstructs my ingress and egress. So there is a change, a double standard, a double conduct, my lord. But if only the interest is to demolish, then it's otherwise. What is there is there, my lord. I beseech your lordship.
We're dismissing the appeal. Learned, the present challenge has been preferred against a judgment passed by the learned single judge, whereby the learned single judge affirmed the decision of the district magistrate under section 10 within bracket 4 of the West Bengal Highways Act, comma, whereby the district magistrate confirmed an order of the executive magistrate for directing removal of unauthorized encroachment by the appellant stroke municipality of PWD land under section 10 within bracket 3 of the said act. Who's up next para? Learned senior counsel appearing for the appellant argues that the provisions of the West Bengal Highways Act, comma, which is a state act, comma, are not applicable in view of section 3 of the Government Buildings Act, comma, 1899, comma, the latter being a central act. Who's up, it is contended that in terms of section 3 of the 1899 Act, comma, nothing contained in any law or enactment for the time being in force to regulate the erection, re-erection, construction, etc. of buildings within the limits of any municipality shall apply to any building used or required for the public service or for any public purpose, where now which is the property, or in the occupation, of the government. For sub next para, Learned Senior Counsel submits that the subject property is being used by the appellant stroke municipality for the purpose of a public toilet, which comes within the purview of public utility services, and as such, the bar under section 3 of the 1899 Act is attracted. For some next para, Learned Senior Counsel next contends that the learned single judge proceeded solely on the premise of previous orders passed by this court, whereby the authorities were directed to initiate proceeding under section 10 of the West Bengal Highways Act, on a tentative finding that the occupation of the appellant on the subject land was an unauthorized encroachment. First of, however, without any due adjudication under the provisions of section 10 of the West Bengal Highways Act, the said finding could not form the premise of a direction for removal of the encroachment by deeming the same to be unauthorized. For sub next para, thirdly, Learned Senior Counsel argues that permission was granted in principle by the respondent authorities for use of the said premises by the appellant municipality for the purpose of setting up a public utility service by way of toilet. For sub next para, Learned Senior Counsel places reliance on documents annexed to the connected stay application, which were also produced before the learned single judge, in support of such contention. For sub next para, Learned Counsel appearing for the state as well as the private respondent stroke complainant oppose the submissions of the appellant. It is submitted by the respondents in unison that the purported permission was being considered by the respondent authorities in the context of plot number 1452, whereas the present dispute relates to plot number 751 by 1452, which are different plots. For sub next para, it is further argued that the provisions of section 3 of the 1899 Act are not applicable in the present context at all. Full stop. Even otherwise, Learned Counsel for the respondents argue that the procedure contemplated in section 10 of the West Bengal Highways Act were fully complied with, and as such, there is no scope of interference by this court. So next para, insofar as the argument of the appellant regarding applicability of the 1899 Act is concerned, the court is unable to accede to such contention. Next para, section 3 categorically includes a non-obstante clause only in respect of statutes to regulate the erection, re-erection, construction, alteration or maintenance of building within the limits of any municipality. Full stop. A bare perusal at the objects and purpose as well as the preamble and the provisions of the West Bengal Highways Act clearly indicates that the said act operates in a different sphere altogether and is not a statute to regulate the erection, re-erection, etc. in respect of buildings within the limits of any municipality. Thus, the bar under section 3 of the 1899 Act, in any event, is not attracted to a proceeding under section 10 of the West Bengal Highways Act. Next para, insofar as the purported permission is concerned, we find even from the documents relied on by the appellant that those, at best, relate to plot number 1452. Although, initially such permission was accorded in respect of other plots, as apparent from the body of the said communication, even giving the benefit of doubt to the appellant, comma, since the caption of the communication included plot number 1452, and there were subsequent correspondences whereby it was prima facie indicated that the respondent authorities had the intention to hand over the plot to the appellant municipality, comma, we may assume, comma, without conclusively holding so, comma, that there was some primary discussion regarding handing over the plot, regarding handing over the said plot to the appellant. Full stop. However, comma, all such correspondence relates to plot number 1452. Full stop. Next para. The argument of the appellant that plot number 751 of by 1452, comma, which is the subject plot, comma, is a single inverted with the bata inverted close plot, comma, carved out of plot number 1452 is not tenable in the eye of law. Full stop. It is common knowledge that when subplots are carved out of a parent plot, comma, the numerator of the fraction denoting the subplot is the number allocated to the parent plot. Full stop. In the present case, comma, however, comma, the parent plot was 1452, whereas the subject plot is 751 by 1452. Full stop. Since the number double inverted 1452 double inverted close comes in the denominator portion of the fraction number of the plot, comma, it cannot be that 751 by 1452 was a subplot carved out of the parent plot 1452. Full stop. Next para. That apart, comma, nothing has been produced before any of the forums, comma, the learned single judge, or even before this court to indicate that the said subplot was carved out of plot number 1452 and or the two are identical. Full stop. Hence, comma, the argument as to permission having been granted to the appellant in respect of plot number 751 by 1452 can be ruled out at the outset. Full stop. Next para, we find from previous rounds of litigation that there was an earlier direction by a learned single judge directing the respondent authorities to initiate proceedings under Section 4 of the West Bengal Highways Act on the prima facie finding that the appellant is in unauthorized occupation of the subject property. Full stop. The division bench, comma, while affirming such judgment, comma, observed inter alia that a special officer appointed by the court had submitted a report on February 10, 2021, to which the appellant had not filed any objection. Full stop. It was recorded that the said report of the special officer indicated that the appellant had made construction over the subject land belonging to the PWD without approval of the PWD and also blocked the ingress and egress of the then writ petitioner, bracket A, present private respondent, bracket closed. Full stop. After going through the report, comma, the Honorable Division Bench found that the learned single judge had passed an order directing the executive engineer to initiate proceedings under Section 10 within bracket 1 of the West Bengal Highways Act, bracket 1964 Act, bracket closed, for removal of the illegal construction. Full stop. Such order was accordingly affirmed by the division bench. Full stop. Next para. Hence, comma, although the finding as to the construction being unauthorized, comma, in the absence of any further challenge to the order of the division bench, comma, the appellant cannot now resile from such position and argue that it had duly obtained permission to enter into the said plot. Full stop. Next para. Even otherwise, comma, by arguing that permission was given to the appellant by the respondent authorities for construction of the unauthorized structure on the property, comma, the appellant has, comma, by implication, comma, admitted that the land belonged to the PWD and not to the appellant. Full stop. The plinth of the appellant's defense was that permission had been granted to make such construction by the PWD, which has been belied by the materials on record, comma, as discussed above. Full stop. Next para. Even before the executive magistrate as well as the district magistrate, comma, no document was produced to indicate any such permission having been granted regarding plot number 751 by 1452. Full stop. Thus, comma, the learned single judge proceeded on such premise and came to the conclusion that the appellant, that the authorities had not committed any error in directing removal of the encroachment. Full stop. Next para. It is well settled that the scope of an intra-court appeal is limited, comma, only to patent illegalities stroke perversities, and the appellate, comma, in a latest patent appeal stroke mandamus appeal, comma, does not readily interfere with the exercise of discretion by the learned single judge. Full stop. Next para. In the present case, comma, since we do not find any error of law or fact and stroke or perversity in the impugned judgment, comma, there is no scope of interference in the appeal as well. Full stop. Next para. Accordingly, MAT 935 of 2026 is dismissed on contest without any orders to cost, comma, thereby affirming the impugned judgment dated May 18, 2026, passed in WPA 20056 of 2022. Full stop. Consequentially, CAN 1 of 2026 is also dismissed. No orders to cost, urgent settlement.
Supplementary affidavit be taken on record.
প্রথম লাইনে একটা করে দাও। আচ্ছা, আরেকটা মাঝখানে একটা না দিয়ে ওই যেখানে লাস্টলি বলে করে দাও, ওই যেখানে ডিসকাস করতে লাস্টলি, কমা, learned senior counsel for the appellant relies on such and such reported at 2016-12 SCC 342 in support of his contentions, full stop. However, comma, in the said judgment, comma, the Honorable Supreme Court was considering a case of compassionate appointment, full stop. In such context, comma, it was observed that the Honorable Supreme Court did not find any justification on the part of the state to dig out the appellant apostrophe S case after 15 years of his appointment and terminate his services on the ground that as per the state policy, comma, the appellant did not fall within the definition of the expression double inverted dependent of deceased double inverted clause to claim compassionate appointment. Full stop. Needless to say, comma, the said context was entirely different from the present. Full stop. In the circumstances of the reported judgment, comma, a compassionate appointment had been given to the appellant, comma, which was sought to be terminated 15 years thereafter by the state. Full stop. However, comma, in the instant case, comma, the appellant has all along been found to be in unauthorized occupation of the subject property, and proceedings were initiated at the threshold on the complaint of the private respondent. Full stop. Even otherwise, comma, we do not find any procedural error on the part of the respondent authorities in passing the order of removal of such encroachment. Full stop. It is trite law that the writ court does not interfere on merits with the outcome of an adjudication in accordance with law, but only passes necessary directions in the event there is a patent procedural irregularity, comma, which is conspicuously absent in the present case. Thus, comma, the said judgment does not come to the aid of the appellant. তারপর যেটা, thank you. আর ওই সাপ্লিমেন্টারি এফিডেভিট ফাইল টু বি কেপ্ট অন রেকর্ডটা প্রথমেই করে। Thank you. Great. Next.
I am for the appellant.
Lordship, I am for the petitioner,
Is
Lordship.
the
Lordship,
evidence service?
proceeding with the appeal.
Petitioner means respondent in the appeal.
Yes, petitioner respondent.
You are the writ petitioner there.
Yes.
Yes.
Lordship, before proceeding with the appeal, Lordship, kindly hear me once what he has done, the technical point, Lordship. What is that? The
Am I
appellant.
functioning?
Yes, Your Lordship.
Yes. Come a bit, take it a bit closer to you.
Yes, Your Lordship. The appellant, Lordship, has preferred the instant appeal, Lordship, challenging the self-same order which had already been impugned in the earlier appeal, has preferred under section 19 of the Contempt Act, Lordship. Is that that petition, Lordship, their Lordship,
This petition
had been
1 minute. 1 minute.
had been pleased to
Let them
pla-
take this point. You will argue this and then. Yes.
Their lordship had been pleased to pass an order by granting him liberty, lordship, to challenge the parent order which has passed in the writ petition, lordship. But in this writ petition, in the appeal, lordship, he has challenged the same order which had already been impugned in the earlier appeal. Lordship, kindly see the lordship division bench's order, lordship. Is that page?
Let her take the objection fully. Then you will answer that and then we will hear.
Kindly see the page 75, lordship. I'm reading the whole order, lordship. Page 75, lordship.
Yes, sir.
Section
Oh.
19 of the Contempt Act.
Yes, your lordship.
You whisper to yourself.
Yes, Lord.
At the
We
time of
hear you.
hearing,
We are telling you. We are assuring you. We will hear you. Yes.
at the time of hearing, learned counsel appearing on behalf of the writ petitioner draws attention of this court to the copy of the order dated such and such passed in the WPA 10034 of 2024. It is submitted that the server copy of the order was duly communicated upon the alleged contemner who has received the same. In course of a submission, learned counsel for the writ petitioner has also filed a copy such and such addressed to the writ petitioner, wherefrom it reveals that the alleged contemner, after receipt of the copy of the order dated such and such, passed an order. Lordship, I'm skipping over this. Kindly come to page 77, Lordship. On perusal of the aforementioned order dated 18/6/2025 as passed by the alleged contemner, it appears to the court that the alleged contemner, in the spirit of the order dated such and such, more specifically paragraph 11, therein, yes, no, Lordship, this is not the order. Kindly, I'm sorry, Lordship, page 79. This is the earlier single benches order, Lordship. Page 79 is the division benches order. Page 79. Yes. By consent of the parties, the appeal and connected application are taken up together. This appeal is directed against an order such and such passed by a learned judge. This court in a contempt application being CPAN number such and such arising out of WPA 10034 2024, it appears that the respondent hearing had filed the aforesaid writ application alleging encroachment by the present appellant on the PWD road. Proceeding under West Bengal Highways Act having been initiated, an order passed directing initiation of proceeding under section 10(1) of the West Bengal Highways Act for removal of encroachment. It appears that alleging that the said order was not complied with by the subdivisional officer Alipur Sodor, a contempt application was filed by the
Yes, ma'am, we have read this order.
Yes, sir.
So, liberty was given to challenge the parent order.
Yes.
Let us hear us for a minute. Parent order was that directing the district magistrate or whoever.
District engineer, lordship.
It is sorry.
Parent
District
in the
parent order is district engineer to initiate
no, lordship,
proceedings.
no, lordship. Parent in the writ petition, he was not a party respondent, lordship.
Let us finish.
Yes, sir, lordship.
Parent order was on the district direction on the district engineer to initiate a proceeding under section 10 of the Highways Act.
No, lordship. No.
It was not that.
No, parent order in the lordship, his lordship was directed. Yes, his lordship was directed to SDO, lordship, to demolish the construction. In that writ petition, he was not a party respondent in the writ petition, lordship. Afterwards, lordship.
To demolish, not to
Yes.
initiate a proceeding.
No, to demolish under section 10(1). Lordship, kindly see the parent
Section
order.
10 is preceded by a notice and all these things.
Yes, sir, lordship. Kindly see page 13.
30.
13, lordship. Is the lordship, kindly see the relevant portion, page 16, lordship, paragraph 11.
Yes.
In view of such, while disposing the instant writ petition, this court directs
Initiate a proceeding.
Yes, yes, initiate.
To remove him.
Initiate a proceeding.
That was the initial direction.
Yes, sir.
That was not complied with. You
Yes, sir.
filed a contempt application.
Yes.
In that, district engineer was a party, only a party. Subsequently, court directed by this impugned order to impede him as a party.
Impede him as a party.
Then against that, they preferred an appeal. Court said this is not a section 19 appeal.
Yes, your lordship.
But he may challenge the parent order.
Yes, your lordship.
But that does not preclude him from challenging this order also. Court did not stop him from challenging this order also.
There was no orders passed.
No
by
order
the
need be passed. If he has a right to prefer an appeal, he can prefer an appeal.
He has to prefer the leave to prefer an appeal, lordship.
No. Leave was given by the division bench for
Yes, your
him to
lordship.
prefer an appeal against the parent order.
Yes, your
Parent order, the division bench did not say he cannot prefer an appeal against this order also. He can always prefer an appeal.
Yes,
That is not an objection we will consider. Let us hear him on merit.
My appeal is 3 point.
Have you sought for a leave to prefer an appeal?
No. Lordship,
You take your seat now.
Lordship, my 3 point. Lordship,
What 3 point? Have you taken any leave to prefer this appeal? You are not a party to the proceeding when the order was passed. By this order, you are directed to be added as a party.
Lordship, that's what I have challenged before your lordship.
You are not a party
I
there.
am writ petition, I am not a party.
If you are not a party, if you prefer an appeal against an order passed therein, you have to take a leave of this court.
Yes.
Whereas we are granting you oral leave. What is your case?
Lordship,
You have
case
been
is-
directed to be added.
Lordship, case is lordship.
You are the alleged illegal encroacher.
No. I am a district engineer to initiate a process against against the enclosure, Lordship. I am a district engineer.
So why are you aggrieved by no, you are who is Acha? You are the district engineer yourself.
I am a district.
Who was directed to be added?
Lordship, the landed single bench directed to the
Who was directed to be added? You are challenging that order. Yes.
Lordship.
He was directed to be added. The original contender was who?
SDO. Is the alleged
Original writ petition direction to the SDO. Section 10(1), Lordship.
But you are the appropriate authority.
No, I am not. No, I am a appropriate authority, Lordship. I am a district engineer, Lordship. District engineer, as per Lordship, West Bengal Highway Act, Lordship, Section 10(1), Lordship. The district engineer was not a part. This is an executive engineer initiate a process Section 10(1). After that, Section 10(2) as SDO, Lordship. The district engineer is not a authority to initiate any process, Lordship. But
let us see the allegation in the contempt application once.
Lordship, kindly see, Lordship, the order of the contempt.
Have you got the contempt application? No. Have you annexed the copy of the contempt application?
Lordship, annex, Lordship.
Where is that?
Lordship. The contempt application, Lordship, page 747, Lordship.
47.
See, this time when you file the application, I am not a party, after I read party.
Understood.
I am challenging the order of the 2nd April 2026, Lordship. The order is changed. Is 75 the order, Lordship?
No, let us see the contempt application. So the executive engineer was implicated in the contempt application.
But contempt application order is direction to the district engineer. As per Highway Act, district engineer has no role, Lordship.
West Bengal Highway.
Lordship, this.
No, we don't need that, but the
Section 10(1).
One. Who was respondent number 9 in the writ petition?
SDO, Lordship.
But the order was respondent number 9 and not any officer as would be authorized by him.
Yes.
But you say SDO in any event that is not the authority.
No.
So you say you are the district engineer who is not the authority, executive engineer is the authority. Now let us see the act. Yes. Which provision?
Lordship.
10.
Kindly see Section 10.
West Bengal বললাম যে এটা তো ন্যাশনাল
Highway Act of 1964, Lordship.
বললাম না ওয়েস্ট বেঙ্গল হাইওয়েজ অ্যাক্ট এটা ন্যাশনাল হাইওয়েজ অ্যাক্ট
National Highway has.
National Highway Act is applicable, not West Bengal. This is National Highway.
No. West Bengal Highway Act, one part.
Is there?
Lordship, there, Lordship.
কোথায়? Which page? Same book. Which page?
Page. This is the WB 4. The Highway Authority or any other authorized by him on behalf of the self-service a notice to him requiring him to remove the encroachment and restore the highway to its original condition with the period specified in the notice.
Highway authority or any officer?
Yes.
So how do you know who is the authority, appropriate authority?
Appropriate the executive engineer of the highway.
Where do you get it?
No, that's not a mention.
That is the premise of your appeal, that you have been wrongly added. You say you are not the appropriate authority.
No. As a highway authority or any other authority.
Yes.
The district engineer is not an authority.
How do you know that? Show us something.
No relation. The Jila Parishad, Jila Parishad, district engineer is Jila Parishad, Lordship. It is an autonomous body, Lordship. Jila Parishad, district engineer is Jila Parishad, Lordship.
District engineer is Jila Parishad.
District engineer is Jila Parishad, Lordship. The Jila Parishad is an autonomous body, Lordship.
দেখি This land belongs to whom according to the,
According to land belong whom, as per section, section.
which authority
That's
belongs
Jila Parishad, the land is recorded Jila Parishad, but Lordship,
But-
as per section 2, section 2,
yes.
double B Lordship. The government road means a road vested the government or under control and administration. That land is controlled and administered by the PWD Lordship. In the public work department Lordship. Jila Parishad have issued a no objection or any initiated process Lordship. There if such requirements.
in the memo you have annexed the impugned order, must have annexed. আচ্ছা এটা প্রথমটাই পার্থক্য।
আমাদের কোনো আপত্তি নেই।
Where is the original order? Personal writ code, first order?
Lordship, first order page order of the page 13 Lordship. Page 13.
This one 11 টা কি ছিল গত কালকে রিট পিটিশন।
Page 13 main paragraph Lordship. Para 8, 9, 11, 12 Lordship.
Who was respondent of 11? You are the respondent of 11 in the
I am not a respondent of the petition.
in the writ petition? Who was respondent number 11?
11 is a private respondent who is
Private.
enclosed this. Reported injuries.
Order দিয়েছিল যে either by himself or any officer authorized by him. So do you notice? আর এখানে বললো যে এখানটা যে বলতে পারছো এটা ইম্পিউন অর্ডারটা on perusal of the dated 18/6 মানে 13টা it appears to the court that the alleged containing the spirit of the order directed district engineer ওখান থেকে তো district engineer কে ডাইরেক্ট করে না respondent number 9 তো SDO who or any authorized officer বলেছে তাই না order বলে or any authorized officer or any officer authorized by him SDO তো authorized করার কোনো পাওয়ারই নেই সে ডিরেকশন তো নেই ইঞ্জিনিয়ার তো কোনো ডিরেকশন দেয়নি তোমার সাথে ক্যাট কে রুটিন কন্টেন্ট অ্যাপ্লিকেশনে কোনো অ্যালিগেশন আছে Executive engineer is already a party in the contempt application.
Contempt application, no Lordship.
Yes, page 26. Already party.
Subdivision officer in charge. Executive engineer party. Executive engineer, Southern Jela, executive engineer or Jela Parishad. Executive engineer is another section. Executive engineer, Southern Jela Parishad.
You say the executive engineer is the
executive engineer highway is the approved authority, Lordship.
He is not a party here in the contempt.
There is no post of executive engineer Southern Jela Parishad, Lordship. assistant engineer, district engineer.
জেলা পরিষদের কি executive engineer? Respondent number 2 is there, executive engineer.
Executive engineer,
PWD
Southern Jilla Parishad,
notes.
Southern.
No, two.
I see.
Two is
Two is the appropriate authority.
appropriate authority. So he's already there, you need not be added. That is your case. Let us hear Mr. Lahiri. Yes, Mr. Lahiri. Why is the premise of the learned single judge was in passing the impugned order was that this the original direction was on him, but respondent number 11 was you. Direction was on 9. Was the SDO?
Private respondent, I am the writ petition.
Acha, very well.
My lord, which order is being assailed? My lord, first is the previous order, it was assailed. There is a division bench.
Previous order is not being assailed before us. The order which was challenged before Justice Banerjee's division bench, where Justice Banerjee gave leave to prefer an appeal against the original order. But we told you, learned junior, who very competently placed the matter before us, that simply because leave was given, it was held, two things were held. One is section 19. No, parent order is not touched. He is aggrieved by his impediment in this contempt proceeding. Parent order, nobody has challenged before us. Justice Banerjee's division bench said two things. One is, under section 19, no appeal is maintainable because this is not a punishment given. It's very obvious. Simultaneously gave him liberty to challenge the parent order. That does not preclude him from challenging the order challenged before Justice Banerjee also. He can also challenge that order because it's not a section 19. The mandamus appeal he can prefer, provided it's a judgment. But how do you justify his implement? You have already implemented the executive engineer. The court proceeded on the premise that he was directed. Para 11 of the impugned order.
First is, subdivisional officer was directed. Subdivisional officer had delegated his powers to him. This is the order.
Subdivisional officer is he the authority, appropriate authority?
There was a direction, there was an authority.
Direction maybe.
This direction has been complied with. If he is aggrieved, then he has to challenge this order, by which he has been directed. This order was placed before the learned court below. On the basis of this, he has been impaired. Kindly see, this order he has to challenge. If he wants to assail his rights.
Understood. Yes. Let us see this.
Order. Order to যেটা দেওয়া
Copy there, আমাদের আমাদের নেই।
You have everything. It has been.
না না আমার
Here, Article 12 authority.
ডিসেম্বরে দিয়েছিল কপি। Dissent.
Give a copy to him also. He never had a copy of this. Poor fellow. Poor guy. How does he know of this? That was not even referred to in the order which you were able to obtain.
This was given.
We'll not interfere with the order. We'll refer to this. We'll keep this on record. We'll record that a copy has been directed to you. Now, as per them, SDO passed an order pursuant to the parent order, authorizing you, or you may subdelegate to your. So that's why you now, as per this, you are a necessary party. You appeared there. We'll leave it open to you to take your point that you are not the appropriate authority under the act. That point you can take before the writ court, before the contempt court. We'll keep it open.
This was given before.
Not even referred to in the order. See the impugned order, Mr. Lahiri. The premise was para 11, which is incorrect.
Or any other authorized officer.
No, para 11 is the premise of impleading you, which it is recorded. In view of such, while disposing, this court directs the such and such to initiate a proceeding under section. Para 11 of the parent order. Now,
quantum order.
No, the parent order para 11 referred to respondent number 9 or anybody to whom he subdelegates. Now, in the present impugned order, in the contempt proceeding, the learned single judge observed in para 3 and 4. Para 3. On perusal of yes, see, it appears to the court that alleged content in the spirit of order, more specifically such and such. Acha, no, acha. The alleged contemner, this. His order is not referred to. Oh, yes, order is also referred to, in fact.
Yes, this was handed over, and on the basis of
But the
this,
date of the order is not correct.
date of the order not correct. The heater.
No,
no.
16.5 is the parent order.
Yes, this is the order.
Parent order. But this order is never referred to in the impugned order.
Yes, yes. 18/6/2025.
Acha, no, aforementioned order means.
This is the order. On perusal,
Acha, acha.
aforementioned order, mentioned
Filed
order
Right.
dated 18/6/2025, as passed by the alleged contemner,
Very good.
it appears to this court circumstance.
Understood.
And in any case,
This order.
And in any case?
and in any case, my humble submission would be,
Hmm.
if a court executing, not executing, exercising its powers under the contempt, finds that someone is aiding and abetting contempt,
Not a judgment under latest patent. Under clause 12.
not a judgment, but see what principle, if those matters where the
No, not amenable to appeal.
this,
No, what is right is decided. That is what you say.
yes, it can be, he can be added. That those matters where
You are speaking in your favor. Adding somebody, directing somebody to be added
yes,
is
not
not.
his. That's
We are not setting aside the order. You please appear before the contempt court and you explain. You can take the point that you are not the appropriate authority under this act. That question will keep open.
if he at all wants to agitate, he has to that I'll go before.
Yes, challenge the parent order.
No, this order. This is also an executive order. If he is
order is
not
saying that this
not
is
necessary. Not necessary, Mr. Dairi. We are not giving a clue to him, but to answer you, may not be necessary. We are just giving this hint. May not be necessary. And a delegation made, even if pursuant to a court's order, by an authority who himself did not have the jurisdiction or the authority,
then it will not be
is bad in law, need not be challenged before any court. Without jurisdiction is a nullity.
without that has to be
So,
substantiated.
if you argue further, we will give him grounds of his appeal to the parent order also.
For the learned court below. That is what was saying.
No, he should immediately challenge the parent order and take these grounds, but we will not elaborate further.
Yes.
He should challenge. He should have challenged that. In fact, you are right. So you can give him a clue on that also. The present challenge. Please take your seats, all of you. If we factually, if we make any wrong statement, then please
Yes,
just correct us. Yes, please take your seat.
So last occasion, court is lordship in contempt proceeding. Court is order lordship violation. Case for paragraph lordship 14 lordship can you see?
What is this?
Lordship, if the court is directed to that, if you have not obtained any stay order, I had proceed against you. Lordship, this is lordship kindly see.
No. We are disposing of the appeal. We are dismissing your appeal. We are saying we will not interfere. You will remain added. The order of the contempt court is correct in view of this order.
Yes.
We will keep it open to you to argue before the contempt court that you are not the appropriate authority. All questions will keep open.
But give some protection, otherwise court is initiated.
We are disposing of your appeal. We don't have. We are not in season of the matter any longer after disposal. What protection? You have been only impeded by the impugned order. You have been added as a party. You appear there on the next date. The present appeal has been preferred against an order whereby the appellant, the district engineer of the South 24 Parganas Jila Parishad, has been added as a party to a contempt proceeding. To sub next para, the genesis of the case is a judgment dated May 16, 2025, passed in WPA 10034 of 2024, whereby the writ petition, you are the writ petitioner, Mr. The writ petition of the present respondent was allowed, was disposed of, directing the respondent number 9 therein, that is the concerned subdivisional officer within bracket SDO bracket close, to initiate a proceeding under section 10 of the West Bengal Highways Act 1964, either by himself or by an officer authorized by him in his behalf, by serving due notice to the respondent number 11 bracket present appellant bracket closed, Respondent number 11, bracket A, alleged encroacher, bracket closed, and stroke or any other person or persons as he may deem fit and proper, comma, for removal of the encroachment and restoration of the highway and stroke or government road to its original condition within a stipulated period. For some next para, subsequently, comma, the writ petitioner took out a contempt proceeding, comma, alleging that the order of the court was not being complied with. Full stop. In the said proceeding, comma, the present appellant was not impleaded as a respondent stroke alleged contender. For some next para, during arguments in connection with the contempt proceeding, comma, the writ petitioner stroke applicant in the contempt proceeding produced before the learned single judge an order dated June 18, 2025. You produced or the subdivision an order dated June 18, 2025, passed by the concerned subdivisional officer, comma, Alipur Sodor, comma, district South 24 Parganas, whereby, comma, purportedly in consonance with the parent order, comma, the subdivisional officer had authorized the present present appellant, comma, that is the district engineer of the South 24 Parganas Zilla Parishad, comma, or any officer authorized by him in his behalf to proceed under the under section 10 within bracket 1 of the 1964 Act, comma, in pursuance of the parent order. Full stop. Next para, upon such order being produced before the learned single judge, comma, the learned single judge passed the present impugned order, comma, directing impleadment of the present appellant as a party to the contempt application. For some next para, learned counsel for the appellant argues that the appellant, comma, being the district engineer of the South 24 Zilla Parganas Zilla Parishad, comma, is not the appropriate authority under the 1964 Act to initiate proceedings under section 10 within bracket 1 of the said Act. Full stop. It is submitted that the concerned executive engineer, bracket A, PWD roads, bracket closed, who is the appropriate authority to initiate such proceedings. Full stop. Thus, comma, it is contended that the impleadment of the present appellant was not tenable in the eye of law and ought to be set aside. So next para, learned senior counsel appearing for the respondent places for the respondent, comma, at the outset, comma, takes an objection as to maintainability of the present appeal. Full stop. Learned senior counsel relies on an order dated May 21, 2026, passed by a coordinate bench in MAT 777 of 2026, comma, preferred against the self-same impugned order as that challenged in the present appeal, comma, which was not entertained on the ground of maintainability, comma, with the observation that the appeal did not appear to be maintainable under section 19 of the Contempt of Courts Act, comma, 1971. Full stop. Liberty, comma, however, comma, was given to the appellant to prefer an appeal against the parent order. Full stop. Next para, learned senior counsel for the respondent argues that since no appeal has been preferred against the parent order pursuant to such leave, comma, the present appeal against the self-same order is not maintainable. Full stop. Next para, learned senior counsel hands over to the court as well as to the learned advocate appearing for the appellant copies of an order dated June 18, 2025, passed by the subdivisional officer, comma, Alipur Sodor, which was apparently the premise on which the impugned order was passed, comma, directing the appellant to be impleaded in the contempt proceeding. Full stop. It is submitted that in the teeth of such order, comma, the appellant was necessarily to be implicated in the contempt proceeding, comma, since it is the appellant who was authorized in terms of the parent order by the concerned SDO to initiate proceedings under section 10 within bracket 1 of the 1964 Act. For the next para, upon a perusal of this said order dated June 18, 2025, comma, this court finds that there is substance in the contention of the respondent, comma, inasmuch as the subdivisional officer had, comma, by the said order, comma, directed the present appellant or any officer authorized by him to initiate proceedings under section 10 within bracket 1 of the 1964 Act pursuant to the parent order passed by the writ court. For sub next para, thus, comma, the learned single judge was justified in directing implement of the present appellant as a necessary party to the contempt proceedings. For sub next para, the objection as to maintainability of the present appeal, comma, however, comma, cannot be entertained. Full stop. The coordinate bench had refused to entertain the previous appeal on the technical ground of maintainability, comma, since by the impugned order no punishment for contempt was meted out, comma, thus taking the said appeal outside the ambit of section 19 of the Contempt of Courts Act, comma, 1971. Full stop. Such refusal, comma, per se, comma, cannot operate as a bar to the preference of the present appeal in substance against the impugned order. Full stop. Even otherwise, comma, merely because the coordinate bench granted leave to the appellant to prefer an appeal against the parent order does not necessarily exclude the right of the appellant to prefer the instant appeal against the impugned order as well. Full stop. Next para. However, comma, on merits, comma, we do not find any scope of interference, comma, since we have already observed in view of the discussions above, comma, that the present appellant was a necessary party in view of the order dated June 18, 2025, passed by the subdivisional officer, comma, Alipur Sodor. Next para. However, comma, it will be open to the appellant, comma, as and when the appellant appears before the contempt court, comma, to urge all points regarding whether the appellant is the appropriate authority under the 1964 Act to be directed to initiate proceedings under section 10 within bracket 1 of the 1964 Act. Full stop. Next para. If such questions are raised, comma, we are confident that the learned single judge taking up the contempt proceedings will deal with the same in accordance with law. Full stop. Be that as it may, comma, there is no scope of interference in the present appeal. Full stop. Accordingly, MAT 1031 of 2023 is dismissed on contest, comma, thereby affirming the order dated April 2, 2026, passed in CPN 2011 of 2025, bracket A in WPA 10034 of 2024, bracket closed, and directing the appellant to appear in the contempt proceeding. Full stop. Next para. না যেখানে বললাম accordingly এটা is dismissed বললাম in the light of the above observations, comma, thereby affirming তারপর যা আছে. Next para, can 1 of 2026 is consequentially disposed of, no address to cost or this. You can take your points before. Why don't you prefer a challenge against the parent order also? Mr. Lahiri has shown you the way and his learned junior.
If such a challenge the parent order,
he'll be very happy.
Required for.
Yes, only if required. Next. Oh, sorry. Six,
6, 7 and 8 all are similar issue.
6, 7, 8 देखिए तो board. You are appearing in all the matters.
In all the matters, only leave to move in representative capacity is required. That's
again, once you have passed, we are dismissing this, then no further appeal will come. Similar must be similar.
Similar.
জানি তো এটা হবে. Yes, Mr. Ahmed, leave is required in which matter?
In
To move the appeal.
Yes, yes.
No, there were
Single judge did not grant leave. Only confined the interim order to the writ petitioners.
no in the appeal. Why should you grant you leave for the first time?
No, for appeal we know.
Oh, acha, that is the premise of the case. Have you brought that judgment, previous judgment?
Yes.
Obviously, you brought. Give them a copy. You know of this judgment. You are there.
I was not there, but
Do you have a copy of the judgment?
Basically দুটো গ্রাউন্ড, একটা তো আর্টিকেল 14,
এদের বইন্ডিং হয়ে যাচ্ছে আমাদের উপর। Similar, exactly similar. Otherwise,
না এক সেকেন্ড,
what is the difference?
নোটিশটা ইমপিউনেটটা
You check up. Same notice? No, cannot be same notice.
no
Similar. Which railway station? Same.
No, this is Halishahar.
We have to see the notice once.
That page 15. In that notice, at a particular
we are looking into MAT 1100.
11 page 15, yes.
700 page 15.
এটা নাম্বারটাও লেখেন, কোথাও লেখেন মানে কি।
So this is a better notice. You have been addressed as brother, so it's much better. We are not interfering.
Yes, in English there is no problem. All hawkers and vendors who are unauthorized by the
It's not there in the English translation.
No.
So we'll go by the English. Yes.
For running the business as Halishwar station.
But this is a better notice, Mr. Ahmed,
Yes,
than the previous one.
the
That was
particular
just structure is unauthorized, leave the entire.
Yes.
But this is only
railway premises.
Unauthorized ones.
All structures are included here.
Let us just check. Warrant authorized by railway administration for running business.
So omnibus notice, not addressed to anybody.
Better. No, but this is justified, Mr. Ahmed.
This is
whoever is in unauthorized unauthorized business is being run by whichever persons, they will remove their shops. 15 days notice has been given. What is the wrong in this?
No, that is the main challenge in the writ petition. In our
court has granted you stay.
Normally in writ petition we have made a prayer for rehabilitation. That is our.
You should have challenged the parent order of the writ court.
state government. This is it.
You are the railways. You should have challenged the parent order. কিন্তু যদি দিয়ে থাকে তাহলে তো সবাইকে কেন দেবেন? Yes, on the limited question which is involved in this appeal, you have a good case.
Yes,
you have a good case.
Only for
if stay is granted, let us see the impugn order once.
At page 12 starts. 12.
What is your full name, please? Your full name?
Kumar.
Mr. Kumar, because we are not sitting in judgment over the grant of this interim order. You have not challenged, so it's there. See, if relief was given to the petitioners, this is not addressed to the petitioners only. This is addressed to everybody. Whoever is unauthorized. So if stay was granted, should have been granted in respect of the entire notice then. Did you plead representative capacity in the writ petition? Just show us that pleading.
Para 1-2.
No, writ petition you have annexed?
Yes. Page 25.
25.
As well as must be para 15 also. No. And para 14. 1, 2 and 14.
Para 14 is 32. Is 30.
Prayer is at page 38.
You are not pressing those prayers before the writ court and coming here and
But
Two
in
courts,
fact, my lord, we had prayed for, but did not insisted for the simple reason that court was not inclined to let grant it to others. In fact, court has recorded that court is decision of the matter. On
what is
hearing,
your
my lord.
argument on this?
But well, give liberty to challenge this matter. To challenge this order matter.
The order which we will pass?
No.
No. What is your argument against them? They have preferred this challenge. They say that this stay order should be extended to all persons because they had also pleaded in the writ petition, sought for leave to file in representative capacity. Yes, that was not granted. We agree with that. But whether that can be granted at a subsequent stage also, before the final hearing.
Well, give me come with an instruction on that.
Why are you appearing today then, if you don't have instruction?
Well, today I just received brief, my lord. And it's today.
I was mentioning the matter before recess because every day we are under threat. That's the whole difficulty. If it is demolished by the time.
Late by Mr.
When is the next date fixed before the writ court?
Lad, on 14th July, the main matter will be hearing, not this matter. This is in the month of up to 31st July. This is extended.
No, this matter, this writ petition is scheduled to be heard.
Yes, man, on
in the impeachment it must be
30th June.
15th.
Pardon? When?
15th July.
June, my lord, it shows page 14, 29 June, the matter
I saw
was 30th June. My
Then
lord,
what happened?
8 July.
You will be able to say what happened then. You were also appearing there, Mr. Ahmed. Both of you, all of you were appearing.
Yes, man. No date has been fixed.
It was not taken up on that date. What? Please let you know this name.
Like, give me 1 day, my lord. I'm led by Mr. Learned ASG, my lord. Mr. Dhiraj Trivedi. Give me 1 or 2 days, my lord.
1 day we don't sit in division bench tomorrow. See, if you evict them in the meantime, it will be difficult. When does this 15 days has expired already? Much back.
Yes, my lord, because the notice says, my lord,
15
on
days.
19th, yes, my lord. Counting from.
It was previously also circulated. It says on 19th, it was previously circulated.
And this was issued on 27th June.
12th June.
12th June.
12th June.
In the meantime, what they did, they have identified the petitioner's stall to remove the others.
27th June, they should. This was the time limit. It expired on 27th.
15 days from 12th of June. That is 27th.
Within bracket at 27th June.
Oh, yes, right. 27th June has already passed, so you have not been evicted. So what?
Well,
What is the urgency?
What has happened, man, in the meantime, after the order is passed, they have identified the petitioner's stall to remove the others. In fact, they have done in so far Paksakas is concerned. They have removed all the stalls except the petitioners. That's the whole difficulty. In Jadavpur, there was an existing order of court, despite that they have removed.
Undertaking the panel থেকে নাম চলে যদি আন্ডারটেকিং দেওয়ার প্যানেল থেকে নাম চলে already gave limited period. We are passing an order for a limited period of blanket stay of this notice for say 7 days. So we cannot take it up before Monday. If you ask for time today, we don't assemble before Monday. We'll keep it on Monday. As Monday কোনো specially fixed আছে দেখুন তো মানডে কোনো স্পেশালি ফিক্স 13 জুলাই আছে মনে হচ্ছে মানডে লিস্ট নেই হাতে কি আছে সন্দেহজনক কথাবার্তা বলবেন না কি এর আগে কি টু মেনশনে অনেকগুলো আছে মানে রিটেন নোটস স্পেশালি ফিক্স কিছু নেই তো we are putting it at the top under the heading specially fixed on Monday. Till Thursday for the time being, we are staying the operation of this notice itself in respect of all concerned. That will be subject to what we pass on. At the outset, an adjournment is sought on behalf of the railway authorities. Full stop, next para. However, in view of the extreme urgency involved, we take up the matter for considering the scope of grant of interim orders. Full stop. The writ petitioners in all these matters. Now, the appellants in all these matters have taken out writ petitions challenging a notice dated June 12, 2026, affixed at the Halishohor railway station, the contents of which are to the effect that hawkers and vendors who are not authorized by the railway administration for running business at Halishohor station / railway premises by keeping their shops, stalls, etc. are thereby informed and also instructed to remove such shops, stalls, structures, etc. from the railway station premises within 15 days therefrom, that is within June 27, 2026, without fail, otherwise the railway administration would be bound to remove all such unauthorized shops, stalls, structures. Full stop. Next para. Learned counsel appearing for the appellants argues that the writ petitioners / appellants filed their writ petitions seeking leave to move the same in representative capacity. Full stop. However, although no specific order was passed at the juncture of passing the impugned order granting such leave, the character of the writ petitions are still in representative capacity. Full stop. However, it is submitted that the learned single judge, although prima facie satisfied and having granted a restraint order directing the respondent railway authorities, restraining the respondent authorities from taking any coercive steps, such order was passed only in respect of the writ petitioners / appellants and not in respect of the other similarly situated hawkers who also come within the purview of the notice. For next para, the limited ambit of the appeal is whether the learned single judge ought to have passed similar orders in respect of the other affected members of the hawker community as well. So next para, we find learned counsel also relies on an unreported judgment of this court in the matter dated July 2, 2026 in the matter of MAT 1071 of 2026, bracket Kartik Chandra Datta and others versus Union of India and others, bracket closed, whereby, in somewhat similar circumstances, a similar notice had been, the operation of a similar notice had been stayed as a whole. Full stop. Next para. Upon a perusal of the notice impugned in the writ petitions in the present case, we find that the same pertains to all the hawkers and vendors who are not authorized by railway administration for running business at Halishohor station / railway premises, closed, full stop. Thus, by the tenor of the notice itself, it places not only the writ petitioners but all other hawkers and vendors, who are allegedly running their shops / businesses in an unauthorized manner in the railway premises of the Halishohor railway station, have been brought within the same bracket, being similarly affected and similarly placed vis-a-vis the said notice. Full stop. Next para. In the context of the prayer made by the writ petitioners that the writ petitions are being moved in representative capacity, comma, even if no such order is passed at the outset, comma, a leave may be granted at any stage before final disposal of the writ petition to that effect. First of thus, comma, potentially, comma, the petitioners have a right to seek representative capacity in the writ petitions. First of next para, even otherwise, comma, proceeding from the perspective of the notice itself, comma, the same unifies all the persons affected thereby. First of as such, comma, non-grant of similar protection to the other affected persons than the writ petitioners, comma, particularly in the light of Article 14 of the Constitution of India, comma, would be a violation of the right to be treated equally before the law by such other persons. Full stop. Also, comma, in view of the writ petitions containing a prayer for leave to move the same in representative capacity, comma, it is open to the learned single judge to adjudicate such aspect as well. Full stop. Be that as it may, comma, since a strong prima facie case has been made out not only in favor of the writ petitioners, but also the other affected persons by the notice, impugned notice, and as the writ court has already granted protective, granted a protection against coercive measures in respect of the writ petitioners, comma, which has not been challenged by the respondent authorities till date, comma, there cannot be any conceivable reason as to why similar protection ought not to be given to the other affected persons as well. Full stop. Accordingly, comma, we grant stay of operation of the impugned notice dated June 12, 2026, annexed at page, this page 13 or 15, two numbers are there. At page 15 of Can 1 of 2026, filed in connection with the present appeal, till July 16, 2026, or until further order, comma, whichever is earlier. Full stop. The matter shall be listed next, comma, in view of the accommodation sought by the railway authorities, comma, on July 13, 2026, under the same heading. এটা plural করে দিও সব কটা। Notice is not the same in all the same self-same notice in all the
Not self-same.
not self-same.
Similar.
Dates are similar.
No, dates are not similar. At page 15 of the next matter.
What are the other dates? 12/6 and the other date one is.
This is May.
In all 15 days has been given.
No, in this notice, 15 days has not been given. Yes, given. It was issued on 5th June and date of eviction they have fixed on 20th June.
WP contract. 1101.
Yes, 1101. At
What
page
is the at page
15, 15.
It is 15. What is the date of this notice?
This is 5th June.
It says possibly 5th June.
5th June,
And
possibly.
After immediately after the signature. Just
In fact, on the signature.
The signature.
Yes.
Very clear.
Possibly 0.
Possibly 5th June,
6.
possibly.
Could be 0.
Assuming there is 15 days gap.
15 days করে দাও কিন্তু যেখানটা জুন 12 বলেছি কোথাও নোটিস ডেটেড জুন 12 কোথাও বলেছি যেখানে জুন 12 বলেছি কমা জুন 5 2026 পাশাপাশি যাবে and what is the third one? There are 3.
It is on 8th
You
June.
can also say
It was on 8th
8 June and June 8 respectively. বাকিগুলো all 15 days given.
Yes.
So they are assisting us more than you, Mr.
Well, just because of this.
No, thank you very much for that. 15 days হচ্ছে না হ্যাঁ এই যে 28 এর মধ্যে বলছি 5 থেকে 15 5 থেকে 15 ই হচ্ছে ইউ আর রাইট Thank you. Calculate করছো ready হয়ে আছে। Yes, Mr. Ghosh.
Can you look into your last order?
Oh, that. Yes.
Substantially hard this matter.
Yes, yes. Oh, that. Rakesh Raman Kavita.
It was adjourned on the behest of the respondent.
They appeared.
Yes, they appeared.
Yes, yes.
They appeared. You have to heard this matter.
Last chance was given to them. Huh? Resolution has been taken, but nobody has mentioned before us. Therefore, we are carrying on.
That's why I appeared.
No, no.
That was highly adjourned. Let me come back on with this.
Maybe under that impression. We're not passing any order because we have given a last chance. If we pass an order, we have to.
I'll hand back on with this.
You inform him, but
I will inform him. Yes. Much.
Tell him that the court was going to conclude hearing, but you had prayed, that's why. So then they'll come. আমাদের কিন্তু কেউ কেউ কিছু মেনশন করতে হয় করে কোনো ইন্টিমেশনই নেই আমাদের yes yes we'll take up matters because no intimation has been given to us. Yes, what is the matter?
Your Lordship, I'm led by Mr. Jishnu Shah and Chakko Sen. They are in their legs in court 32. I'm seeking a short pass.
Is there?
They
Where in other court? Pass over, very pass over. Pass over. আগে দেখে নিন তারপর ফাইল তুলবেন যদি না থাকে।
My lord, I appear on behalf of the appellant. We had finished on the last occasion, my lord. I'm
Who is for the
led by
respondent?
Mr. Ratnanko Banerjee, Zandu Bam and Volini.
Yes, we are fed up with Jhandu and all. Who is for the Mr. Bachawat was there?
Mr. Bachawat was supposed to
Passing over for a few minutes. One of you, through your clerks or somebody, intimate them
We will,
that
my
we are
lord.
taking up the matter. We have passed over. If they don't come, we'll conclude hearing.
Grateful, my lord.
Yes.
For the respondent.
Respondent won't do. You're making not today since they are not there. You are appearing, Mr. Kaur?
No, 16 I am appearing.
No, it will be called on. This is 15.
15, my lord.
15 you are appearing.
My lord.
Din.
My lord.
Paper book din.
Lord, I'm being led by Mrs. Deghosh. She
Mr.
Mrs. Deghosh. Ritupon.
You can start the notes. No difficulty. Yes. Yes.
My lord, the decree of divorce is under challenge, my lord. Suit was filed, suit for divorce was
Take
filed.
the microphone a bit closer.
Suit was filed by the husband, my lord, under section 27(1)(d) of the Special Marriage Act, my lord.
Right.
My lord, the suit was decreed in favor of the husband, my lord. I am for the wife.
Right.
My
What
lord,
is your ground?
my lord,
In
at
the
the-
appeal.
my lord, may I please the section first? 27(1)(d).
Special Marriage Act din. That is cruelty.
My lord. My lord, but what I am on, it's since the solemnization.
Read it out where.
My lord. May I please the full one or the on the
You know the relevant portion. Relevant.
My lord, the section says that 27(1)(d).
Special Marriage Act
Has
possession.
since the solemnization of the marriage treated the petitioner with cruelty. I am on that since, my lord. Admittedly, there was a cordial relationship for several years. A minor son is there. My lord, this is the first point I'm taking before your lordship.
So what is the point you couldn't understand?
My lord, the statute said since the solemnization, my lord. But may I please the judgment, my lord?
Since the solemnization, what do you mean to say? I mean, throughout the period he had to
Immediately after the solemnization of the marriage.
since does not mean.
Since, my lord.
Since means
It is in
ever since, in that sense. After the solemnization of the marriage, he has treated with cruelty.
If I read
Since means after.
My lord, in
This is a peculiar argument, unheard of. Since means on the date of the marriage.
Immediately after, my lord. And it
if
is
someone perpetrates cruelty after a few days of the marriage, then no divorce will be granted.
That is in the Hindu Marriage Act, my lord. There the word after they used.
Since and after are used in a similar sense.
My lord. My lord, I have several
so
other
we'll record
grounds.
your argument on that. So you rely on this to say.
My lord, the word
That is your best argument. You are gone.
No, my lord. Certainly not, my lord.
You're
Certainly
gone.
not.
Yes.
My lord, may I please the judgment first?
There's a judgment saying what you are saying.
No, my lord.
Thank God.
This could be the first one.
No, what else? What are other grounds?
My lord, may I please the judgment, my lord?
Just tell us what are the grounds. Just give us an outline.
The permanent alimony was not at all considered. My counterclaim was not at all considered in the judgment, my lord. And more so, my lord.
Your counterclaim was for?
For restitution of conjugal rights, my lord. That was not at all considered.
No, the restitution, no decree was passed on the restitution.
Yes, my lord. No, decree was not passed, but it was considered. My lord sees the.
No, it was. It's still pending.
No. It has been disposed of.
It has been dismissed.
It was a yes. It was.
Because if that was dismissed, you have not preferred an appeal against that, then you don't have a case here.
My lord, it was within my lord my counterclaim in my written statement.
Counterclaim has the footing of a suit.
Yes, but my lord, it was disposed of, my lord, not under any evidence. It was
No,
disposed
even then,
of while decreeing my lord my suit.
If that was done, if you don't challenge that, then your counterclaim of restitution of conjugal rights stands disposed of. That tantamounts to being dismissed, not
I've
allowed.
taken that plea, my lord, in this appeal also.
No, you cannot. You cannot. You have to prefer a different, distinct appeal against that. If you have not preferred an appeal against that,
My lord.
then that stands. The court has found that you are not entitled to restitution of conjugal rights.
Well, but then that
Then
it
divorce
has
is the obvious, the way out.
it hasn't been dealt with, my lord, under evidence.
Whatever ground, that would be a ground in your appeal against the counterclaim.
My
You have
lord.
to file a separate appeal.
Well, that is not filed, but the point has been taken in this appeal.
No. Cannot. It's a separate decree, has the footing of a separate decree.
What about for? My lord sees the judgment once.
No. Let us see the judgment.
Huh.
Then if restitution stands dismissed, then we have to grant a divorce.
My lord, may kindly see.
After, must have been done some years back, yes. In 2022, this was passed.
My lord.
So after that, 4 years have elapsed.
Well, my
So
appeal
if there was no restitution was refused, then still there is no, reunion. We have to affirm the divorce decree.
My lord, gone for a mediation. My lord, as per my lord, your lordship's
That's
direction.
different. That's different. কি করে বলুন তো? This judgment, judgment দেখিয়ে।
My lord, it is my lord.
Why didn't you prefer a separate appeal against that?
It is the restitution against the appeal file করা হয়নি না?
Appeal file করা নেই তো restitution তো এটা consider করে।
না সে বললে হবে না। Well, the judgment starts at page 69.
Common judgment was passed.
Yes.
But there is no decree on the
No.
restitution.
No, it is not.
So technically it's still pending.
Yes, my lord. But then, my lord, it sees, my lord, the last pages of the judgment.
We have seen that only, 87, 88. Match suit is decreed.
Yes, my lord.
You get a degree of divorce, marital tie is dissolved. There is no finding on then the restitution suit is still pending.
My lord, may I kindly see page 87?
87, yes.
Yes, my lord. So under the aforesaid circumstances, this court has come to the finding that the marital relation of the parties has irretrievably broken. So my lord, this, my lord, is also, my lord, not a ground. And then, my lord, that
No, now after Kavita versus Raman, it's a ground.
My lord, but my lord, this has been disposed of, my lord, in 2022, no? 21.
Judgments need not be retrospective. The judgment interprets the provision of the law, which was
Then,
there.
my lord, may I take your lordship? My lord, there is no ground of cruelty that has been proved. My lord, it's normal wear and tear of the family life.
So you said irretrievable breakdown has also not been proved.
No. Like desertion couldn't have been taken because the suit was filed within 1 year. It's Special
Was not
Marriage
taken
Act.
also, was not
Well, it's
taken.
not taken. Now, well, I was made to leave the house. My domestic violence petition is still pending. The case is going on at the trial stage.
That's a different regime. So
And madam, the last line that there is no place for reconciliation, and in the light of this, there is no scope for allowing the petition respondent's prayer for restitution of conjugal rights. But that I had a counterclaim, my lord. No evidence was led on that, madam. I was not allowed to.
no, separate evidence need not be laid on that. You are not allowed means did you ask for?
Well, that is my
Not allowed means you did not adduce evidence.
Well,
The evidence in the, if it's a counterclaim, the evidence adduced in the suit may be treated to be a counterclaim.
But well, it
evidence.
hasn't been dealt with. But nothing has been dealt with in this judgment. Well, only one line.
As a consequence, it has been done. If a
And my
divorce decree is
second
granted, then what remains?
But I will also prove, my lord, there is
No,
nothing
otherwise,
of
otherwise,
cruelty,
it
my
will be
lord.
very well placed, judge.
My lord. My lord, may kindly start with page 72.
Yes.
Dissolution of marriage under 27D of Special Marriage Act. Now, my lord, first point, my lord, that I would take, my lord, if my lord sees the Special Marriage Act, my lord, it is slightly...
Not accepted.
Not accepted. Achha.
Since means after.
My lord, the term since, my lord, and what my lord is thinking about, my lord, or my lord is, my lord, has in my
I
lord
failed to understand this point. I failed to understand this point since I have been a judge. I failed to understand your argument since I have been a judge on this point.
My lord,
What does it mean?
that
Immediately after I
since-
become a judge, I did not understand. Now I understand.
No, my lord, that is since my lord has become a judge, is from the date my lord has become a judge. So, my lord, since, so we have to prove that my lord has not accepted this judgment the day my lord has become a judge.
No. Since then,
My lord,
if you have
since is the
treated me,
continuity that my lord is talking about, that till date.
as per your argument, then the cruelty has to be on the from the moment of marriage. There has to be cruelty.
My lord.
At the time of Shubhodrishti, you wink or you make a face. That
My
has
lord,
to be there.
no. My lord, that is all right. Madam, I'll not take
That's
that
an
point
observer.
for the time
Please
being.
don't, Ms. Deghosh, don't pursue that. Yes.
Now, my lord, the respondent during their visit at the house, it is 16.
Let us start from page the first page.
My lord.
Page 7. Not a very long judgment. No, it's a long judgment. Sorry.
Well, it is. Well, I will only point out a few portions that are relevant.
What was their case? Let us see. Just we'll just look into it.
My lord.
Your child is what is the age of your child?
Well, he is now 13, no? 12.
Ms. Deghosh, please ask your clients not to exhibit themselves in court. Please ask them to have a seat. We are not interested actually. And ask them not to make faces before the court. We are not bothered with
But I had asked
how sad one is or how happy one is. We are not bothered with that. We are only on the papers.
Well, he is 12 years old now,
Right.
and he's in class 7.
Businessman runs selling luggage. Only son.
Well, a negotiated marriage.
Negotiated
And
marriage.
the advertisement was given, my lord, for a bride. There was negotiation. She then wasn't, she had mentioned that she had only passed class 12.
Right.
Now, my lord, later on a thing came that she had not been able to clear class 12. So she was in class 12, and that is one consideration.
That is a
Now, my
cruelty.
lord, then, my
That
lord,
is a cruelty, suppression. He has treated that.
not, my lord, they have not
Yes.
substantiated it.
Yes.
Now, my lord, she was not given any opportunity to study thereafter. So, my lord, she is completely dependent on the family that she had been married
That
to.
is not a very good ground of divorce also.
My
Otherwise.
lord.
Started causing. You are appealing for the other side? Please.
Led by Mr. Samuel Chakraborty.
Mr.
Samuel Chakraborty, Lordship. I think he has left the court today.
After the matter was, oh, acha, yes,
No,
they,
my lord,
let
due
us
to
hear her.
action
Let us hear her. Let us complete the argument of this side. Yes. Yes. Left no stone unturned. So, page 71, second
Valid.
paragraph is one of the grounds. On disagreement, you became furious and started inhuman mental cruelty.
Threat of lodging complaint. Matlab, this is my little right. If there is cruelty and I have my domestic violence, which is proof, I have whatever he has lodged are GDs, and I have a criminal case which was pending. They had faced trial, subsequently acquitted.
That doesn't
But
help
when
you.
there was a charge sheet of 324.
Also does not help you. In a civil suit, you have to independently, he has to prove. And you have to revert.
Now what his Malat will kindly see, Malat just go through the judgment once, Malat
Yes,
then
let
Malat
us
paragraph 4
continue.
at page 71.
He also lodged GD entry.
Yes.
Great.
Now his is only GD.
His is only GD. Yours is a
Yes.
criminal case that doesn't mean anything. Yours is not on a higher footing.
Yes, my lord.
Both are
Well,
cruel to each other then.
No, my lord, it's not cruelty. He has mentioned about incidents, my lord. I will take your lordship. It is improbable. Well, when they have themselves said that it is admitted that 5 years, till 5 years of marriage, they were having a very good life together. But still, he has exhibited one document where I have said, I have written, which is at page 153, that I am giving all my ornaments that has been given by my mother to my mother. When everything was running good, and this is, well, the marriage was in 2009, and I am writing this in 2009. 153, he has exhibited this document. When everything is good. This is one of the documents that has been an exhibit, Mallet, in his.
How does this help you?
Mallet, this helps me because I will show to your lordship, Mallet, whatever he is trying to build is a plot. But then, Mallet, ultimately, there is no cruelty that can be, Mallet, meted out, Mallet, by this wife on the husband. From these documents, it, Mallet, cannot be established.
So apparently, we find from page 71 and 72, his arguments are discussed. His case is discussed, where the court says one is vague, causing inhuman cruelty, mental cruelty by your language.
My lord.
No specific instance. Appreciate that. Next is 7-8 days. Each time you went to your matrimonial, your parental home, you.
Well, this is also admitted that my mother was I am the single child. I had no father during my marriage.
You stayed
So
at your
only my
parental
mother
home
was
and
living.
occasionally and
Yes.
came here and stayed. Very well.
And Malat, even he, Malat, is the single child. Even his father is not living. So both sides, Malat, one mother.
Understood. So first two allegations are not, maybe not.
My lord.
GD entry by you? Oh, he has lodged a GD entry.
Yes,
right. And workplace, you have used abusive language in his workplace.
My lord. And that too, my lord, he has mentioned about his mother and uncle and aunt. Nobody is a witness.
That was what we are going to ask.
My lord.
Apart from him, nobody adduced
Nobody.
evidence.
No neighbor, no independent witness. Well, nobody. The court has only dealt with the documentary evidence, that too only GDs, based on which, my lord, this judgment has been passed. The other ground that he has taken, my lord, that I used to go and stay. I have left the house, and I wanted to stay with my in a separate abode, where my mother-in-law is not present. So this is one allegation. Now, my lord, there is one one portion that I would like to show to your lordship. At page 81. para that starts at 81, my lord, she also raised serious allegations. So, my lord, until and unless, my lord, there are reasons of harassment for which I am supposed to leave, my lord, that will not amount to cruelty.
But you also adduce evidence, only you adduce evidence.
Yes.
Very good.
And, my lord, here is a ground, my lord.
Any proof of abortion?
I had, my lord, but, my lord, I have not exhibited it. I still have, but I have not exhibited it.
No order for 27 here also.
My lord, this was, my lord, basically this was done through, my lord, legal aid.
Legal aid?
My lord, at my lord, the trial court stage.
But before this court, you could file.
My lord, this court I filed.
No, this was handled by the legal aid in the trial court.
No.
No, my lord. No.
Court appointed advocate.
Your allegations are also serious. First one, these if unproved tantamount to cruelty. Page 81, last paragraph.
My lord.
Conceived for a number of times and all, no document, Ms. Deghosh. Could have just produced the documents. You must have been treated by some doctor. Conceived a number of times means you aborted a number of times.
But that documents are also there.
Documents are there.
Yes.
Why didn't you file an order for 2027 application then?
My lord, after
if you make these allegations, fail to prove, these are serious allegations.
my lord.
Very serious in matrimonial life. Subjected to forced
lord,
abortion.
Difficulties, my lord, I wanted restitution. I did not want any counter cruelty allegations to be established because, my
No,
lord,
but you had to substantiate your case.
my lord, I'm only defending, my lord, saying that he has not been able to prove cruelty and I want to get back to my matrimony.
Then why did you make these allegations in your pleadings?
My
You
lord,
should have made these allegations.
these
If we accept your contention to be correct, you should have just kept mum.
This is my question, my lord, that I had asked, my lord, because, my lord, there was domestic violence. These allegations
You
were
have
taken in
alleged,
domestic
Ms.
violence.
Dekhosh, these are very serious. You were subjected to forceful abortion in the month of January specific, 2014. She was not even provided sufficient food and other essential amenities. You could have also produced, adduced
My
evidence.
lord, there are also, my lord, other allegations of forced.
Humiliated in presence of friends, neighbors, and relations. If they are friends, you could have brought them.
My lord.
Neighbors, you could very well have brought. Conceived a number of times due to adamant and forceful sex of the and all these things. These are, I mean, at least the abortion papers you should have produced. Nothing. But if you make these allegations, don't prove them, then Ms. Dekhosh, they are cruelty by themselves. See, come to page 82, please. What proof have you produced? Petitioner husband insisted earlier her mother continuously to for developing the parent. You have named a person. Why didn't you bring that person simply? What do you mean by this? The Bagui was appointed as developer and one agreement was held. But ultimately you were deprived, your mother.
My lord,
But
this
that
was-
agreement fructified. There was a development
My
agreement.
lord, there was development through another developer.
So nothing has been produced. No document, no
My lord.
oral evidence.
But everything is there, my lord.
What everything?
But I have seen, but
You have
nothing
seen,
has
why
been
didn't you-
produced.
why
Like
didn't you
nothing
file-
is exhibited, my lord.
Why didn't you file an order for 2027?
My lord, because, my lord, my client wants to get back to the matrimony, does not want to prove cruelty.
Now that purpose will fail because we find sufficient materials in the court's judgment.
But, my lord, these are, my lord, this document, my lord, the judgment, my lord, is by the court, and, my lord, the proceedings are between parties, my lord, not for public. The proceedings. So, my lord, these allegations will not be defamatory because, my lord, they have been, my lord, in court and in the proceeding.
Baseless allegations of a serious nature, there are umpteen judgments saying that amounts to cruelty.
But, my lord, these allegations, my lord, have to be in the in the form of a complaint or
No,
my lord,
in the pleadings.
my lord, in the pleadings, but my lord, when they are not my lord in the plaint, they are in the written statement. So my lord,
How can you
Well,
make
in
allegations in the
defense, my
pleading? You are
lord.
the defendant.
My lord,
So it will be a
my
written
lord, in
statement.
defense. So my lord, that cannot be defamatory.
100%. No question of defamation. That
My lord,
amounts to
the learned
cruelty.
judge has my lord called it defamation.
Anyway, let us see. Let us carry on. Assaulted by iron scale, causing injuries.
This my lord is there, my lord. It is his document.
She
He has exhibited it.
You were treated in Arjikar hospital.
My lord.
He beat you up and had you treated and produced that document in evidence.
My lord, because I had raised this question on the GD on my FIR, he has taken my lord out right to information. Under right to information, he has taken the document out and my lord, he has exhibited it.
What is
And
that document?
my lord, that is my lord, page 141. He has got it at page 38 through RTI.
This was exhibited by the husband.
My lord.
What is the exhibit number?
কত রে? 8 হবে বোধহয়। 5.
Yes. Why did he exhibit this? To show that you are cruel against him. False allegation.
My lord.
Acha, any
No, my lord, because he wanted to show that I come to the shop.
So the representation was equal on part of both parties. And is there any document to show that you were treated in hospital?
Well, not exhibited.
Then you have made several allegations in your written statement, failed to prove even one of those. Why shouldn't this be sufficient cruelty? You make these allegations, then you take the umbrella of your innocence, you are being naive. I wanted to go back, that's why I did not exhibit. But that did not stop you from making these allegations in the written statement.
My lord.
Then you admitted that it was marital relation was cordial up to the birth of the child.
My lord.
That means after that it was not cordial.
Well, they had, my lord, inflicted torture upon me and I had raised my
Failed to prove it by any cogent evidence, apart from your evidence, oral evidence.
My lord.
You have stated that it was in front of neighbors and friends.
My lord.
But still they don't come up.
My lord, I have not made them witnesses. And even he has not made them witnesses. Not even his mother.
Your allegation. Even if suppose
his cruelty also, my lord.
Suppose he fails to prove his case of cruelty.
My lord.
You make these allegations.
Well, and mine would be counter cruelty. And if he has to first prove his cruelty, if he is unable
after the evidence is laid, there is no first, second. There is no question of initial onus, second burden of proof, rebuttal. All evidence is on record. Court will see whether cruelty was meted out by either party.
My lord.
Even if he could not prove your cruelty before the filing of the suit, your allegations are unsubstantiated by any evidence. You say he beat you up and you were treated in a hospital, no document. Several times forced sex, abortions, no document, not a single document of any abortion. Something must be there. Getting admitted in the hospital would do. There is no evidence. No evidence.
There is no
Exhibit A series does not, only one GD entry, one exhibit A, And X is for identification. We cannot look into that, whatever that is. You did not lodge a complaint. You lodged a GD entry on an incident in the shop. But
Yes.
when he turned you out of his matrimonial home, you never lodged a diary.
Well, I
You lodged
wanted it to be
domestic violence cases.
yes, quasi civil, my lord.
Yes, but that does not help you. Yes, indecent defamatory allegations. Defamatory allegations need not necessarily mean defamation in law. Defamatory means derogatory. Page 84, which we are referring to. See, page 84.
My lord.
Sufficient
It is
findings. Please
pertinent.
place page 84, Ms. Deghosh. Place it in the
In
present
the present case, documentary evidence as relied on by the petitioner husband reflect a clear picture that the respondent wife, by her ill conduct and behavior, created acute mental pain, agony, and suffering, with the threat of initiation of police case on the petitioner and his widow wife and his widow mother. My lord, this, my lord, is, my lord,
probably not substantiated much.
well, it is not substantiated, and now, my lord, this is after his initiation of the proceeding, my lord, that has come up in written statement.
No, that can be cruelty also. Let's continue after that. The allegation.
The allegation of unilateral decision of the petitioner to forceful abortion and his application of adamant such as such without precautionary measure, resulting in repeated pregnancy in the absence of proper documentary evidence, do no doubt affects physical and mental health of the petitioner husband.
Not very happily framed, but in the absence of proper documentary evidence, these allegations do amount to cruelty, mental cruelty. That's what the court meant.
Malad, that is what is Malad. Malad, in my humble submission, Malad, he has already lodged the case against me on the ground of cruelty. At such stage, Malad, he has not come up with these. These have come up in my written statement. So, Malad, what does he have to prove is what I'm asking myself.
Ms. Deghosh, you know very well. Even after filing of the suit, in your written statement, if you make any pleadings which tantamount to cruelty, serious allegations, unfounded, baseless, not proved by you. And these are not facts which could not be proved. Yes, we can appreciate what happens within the four corners of the room, which are also in the allegations you could not prove. Might be. But the fallout of that, the abortions, several times abortion you have alleged. Forced, he forced he forced himself upon you. That you could not prove, we can understand, happened within the room. But the fallout of that, you have alleged there were several pregnancies and forceful abortions. Not a single document regarding any of the abortions. You could have proved this. You were treated in the Arjikar hospital, you have stated here. Not a single document to show you are admitted or you are treated in the outpatient department also. Nothing. Nothing from your end. No corroborative witness. Thirdly, you have stated in front of friends and neighbors, cruelty has been perpetrated repeatedly now you have failed to produce one of the neighbors even or friends or anybody. Relatives, his relatives you cannot produce. Neighbors, friends, you could have summoned them.
Produced, my lord, the FIR and, my lord, that I was treated. That is a document under Caesar list. This was, my lord, part of the proceedings that was pending. I had mentioned it was not exhibited, my lord.
Should have been called from the records under Order 11 can do that. Rule 10 probably. You can seek a production of the documents of some other proceeding also.
My lord,
So
but my lord, it is not there in the proceedings at all. The LCR will not have this document.
That is what we are saying. LCR does not have it because you did not produce those documents.
My lord, it was
Those
not
should have been exhibited by you. Three things we find. One is abortion allegations repeated, not once. And not mere abortion, as a result of him having forced upon you. So it's a continuum. So abortion would prove that he had forced himself upon you. Repeated abortion, no document. Secondly, repeated cruelty in front of friends. We are not writing a judgment, but making notes for that. Friends.
My lord, if there is any scope of giving me any,
we are trying to do that. Give us something, some handle. Give us some handle. Friends, neighbors, and relatives. No corroboration. Acha, this developer part, you name a developer, you say there was an agreement, nothing produced. Your mother was duped by him. That is your allegation. All these allegations are in your written statement.
My lord.
If you are really agreeable to come back, and as you say, as you are trying to portray, it's not borne out from the records, that you are a meek lady, you wanted to come back, that's why you did not prove anything. But this did not stop you from making those allegations in the written statement. Once you make the allegations, you never amended your written statement, never withdrew it. What can we say? হেল্পটা করবো কিছু নেই মেটেরিয়াল, সবকটা তো ডিল করেছে জাজমেন্টে, ভুল জাজমেন্ট কি করে বলবো?
My lord, if there is a scope for remanding it back, my lord, to my lord, the boy is now, my lord, in class 7.
You have exhibited the boy. Exhibit A and B are before us. Why do you encourage your clients to come?
When I even asked her to stay outside.
You know the court, Ms.
My
Deghosh.
lord.
You know the court.
বলেছি না।
Should not have been present in court. You pointed out to the son when you asked the age of the son. Anyway, that is not material, but you should have dealt with Kavita versus Raman. That case is there. Justice Sudhanshu Julai, because they will cite it.
My lord.
Mr. Chakravarti will not cite any judgment. What judgments will you cite?
Amar Ghosh versus Jaya Ghosh.
Amar Ghosh led to that other judgment.
Huh?
My lord,
Amar Ghosh is the last judgment you are citing. Latest. No other.
My lord, this one even I am relying on.
Forget. They are not citing Kavita. Yes, you cite your judgment.
The Shamar Ghosh and versus Joya Ghosh only, my lord, I'm
Yes,
citing.
yes, Shamar Ghosh, Jaya Ghosh. Law has taken a journey after that, after Shamar Ghosh. Which paragraph you are relying on?
My lord, I am relying on, my lord, when it is cruelty. Paragraph to what?
Give us the paragraph. The paragraph.
My lord, sees
Amar Ghosh তো রিলাই করেছে।
আর একটু নিয়ে আসিস না।
কি বলবো? উঠেছে পাঁচুর মায়ের মতো করে দাঁড়িয়ে আছে। কি একটা ভেঙে যাবে কি করে? Permanent alimony was granted to you.
No, my lord.
That we can consider. That we can consider.
My lord,
Anyway, let us.
my lord,
No, we'll come to that later if you affirm the judgment. Yes, which paragraphs? Give us the
my
paragraphs.
lord, just my lord, give you. My lord, may kindly see page this is my lord, paragraph 101. Yes.
Come to Roman 14.
My lord.
This was relied on in Kavita versus Raman. That's why you are pointing this out. রামনটা কত? সাইটেশনটা ওকে দিয়ে দিলে তাহলে ওকে ডিল করে নিতে পারতো। ওকে তো নোটিশে দিতে হবে।
Continuous separation. If your lordship may kindly, my lord, remand for counter, my lord, consideration of the counter claim, my lord.
Nothing remains in the counterclaim.
Only, my lord, the only thing is, my lord, his grounds for divorce, my lord, were that I had a desire to live in a different household, and I used abusive language against the
No,
father.
he has not been able to prove those.
My lord.
We are more on this. The marriage has broken down irretrievably, and your allegations which you have not substantiated by evidence, those become more crucial. His allegations, whatever evidence, his own evidence only, so not much. But you have helped him out by making allegations and not proving those. And allegations are very serious. He trying to dupe your mother by swindling your property, and the other allegation is all the more serious.
My lord, that has also, my lord, once
Several
been
abortions
dealt with by this honorable court, my lord, in
Cite
Justice
your judgment.
Banerjee's judgment.
Acha, please take note of this judgment.
My lord,
This is, give us half a second. One second. This is reported at 2023. Please take down 2023 17 SCC 433. 2023 volume 17 SCC 433. Rakesh Raman versus Kavita. Most probably paragraph 18. We'll just check up. Somewhere around paragraph 18. No, not 18. We'll just check up. We'll just tell you. Paragraph 22 and 23 of the SCC online. Paragraph 22 says, irretrievable, what you are saying, irretrievable breakdown of a marriage may not be a ground for dissolution of marriage under the Hindu Marriage Act. Here, special marriage. But cruelty is. A marriage can be dissolved by a decree of divorce inter alia on the ground when the other party has, after the cruelty has been. Para 23 says, in our considered opinion, a marital relationship which has only become more bitter and acrimonious over the years does nothing but inflict cruelty on both the sides. To keep the facade of this broken marriage alive would be doing injustice to both the parties. A marriage which has broken down irretrievably, in our opinion, spells cruelty to both the parties. As in such a relationship, each party is treating the other with cruelty. Next sentence is very crucial. It is therefore a ground for dissolution of marriage under section 13(1) IA, which is
comes from
equivalent.
Dastane versus Dastane, my lord.
Forget
comes from-
Dastane. Everything. This has put a terminus on this entire debate. Now, whatever Supreme Court has been advising the legislature to do this for a long time, to incorporate this. In this judgment, it has been categorically incorporated within the definition of cruelty. And there are subsequent one or two judgments by Justice Nagaratna. There is a judgment, but forgotten the name. I don't, very bad. But even then, that was under 142. Court was dissolving a marriage. Court held, quoting several judgments, that all these cases under 142 it has been done. We are also doing it. That was in a transfer application by the wife from one court to another. Court granted divorce, and in that context, no, that is not relevant to you. There, Kavita Raman was also this was also quoted, but it was not observed that this is under 142. In respect of the other judgments, it was observed that those were under Article 142, so not binding precedent. And court in that case also, Justice Nagaratna did that. In a transfer petition, granted divorce, saying irretrievable breakdown under 142. But Kavita Raman, Raman versus Kavita was considered but not held to be under Article 142. Therefore, it's 141, it's binding. So please consider this and come. You complete your arguments, rest of your arguments today, and we'll just keep it for that. Yes. What other judgments you are going to cite? Division bench, Justice Banerjee, some.
No, my lord, Justice Banerjee at page 116, my lord. While this proceedings, 106. Beg your pardon, my lord.
What about this?
Well, this is, my lord, when, my lord, alimony was not alimony, maintenance was declined, my lord. We had come in a revision. At that stage, my lord, may
Sent to
kindly
mediation.
no. My lord, last line, last paragraph. The grievance of the petitioner is the matrimonial code did not allow any alimony pendenti lite on litigation cost to the petitioner merely on the ground that the petitioner has inherited some property and part of the property had been sold or a development agreement had been entered into. In
This was
respect-
at the stage of
When in
alimony
revision,
pendentility.
yes.
That has no bearing.
At
So
that
he is going
stage-
on paying those 10,000
Yes,
rupees.
Mallet. Now,
Going-
Mallet, now 10,000. After filing of this appeal, Mallet, it was increased to 20,000 for the child and the mother.
Yes.
And there was one-time litigation cost of 25,000.
He's paying that.
That he's paying. And Mallet, there was a specific direction, Mallet, to the parties not to marry.
Obvious.
Mallet.
Mediation has failed.
Mediation has failed.
Per month, how much you said?
20,000 per month. Well, while we were discussing, Mallet, it so happened that we were discussing because, Mallet, what has fallen from your lordship, Mallet, was anticipated. And, Mallet, we were discussing, Mallet, that till the child becomes, Mallet, established in life, Mallet.
What does the husband do?
Well, he has a big business. He has the business of travel goods. And at Bidhan Shoroni, he
What
has
goods?
his shop. Travel goods, Mallet.
Travel,
Suitcases,
travel.
yes, travel goods.
You don't do anything. You're on.
I'm only, Mallet, I'm not even past class 12.
Yes.
And that is what I was suggesting, Mallet, that Mallet, till my child, Mallet, till the child.
What would be a good amount? Tell us.
Mallet,
Mediation
now,
must have failed on that.
no, Mallet. Mediation was on the ground, Mallet, for taking back.
Taking it.
Because even the child doesn't want the father to leave, Mallet, not to have that name, Mallet, that he is without a father. So he does. He expressed
He will not be
himself.
without a father.
Mallet, he expressed himself
Father
that
cannot
way.
disown his son. Father remains the father.
Mallet.
Can we compel when did they last reside together? In the year 20?
Mallet 20.
Not even 20.
14.
2014.
December 14.
12 years back. We cannot compel them to go back with the course. Permanent alimony suggest an amount, we can put it to them and they'll consider.
Mallet, something monthly, Mallet.
Monthly, if they don't pay, then you'll have to run to.
Mallet, we will, Mallet, file a proceeding, Mallet, but then that is going to be more secure because, Mallet, for the expenses that are
20,000 then remains. 20,000 is already being paid.
and Mallet, till his education is completed, and Mallet medical, whatever Mallet medical help he needs in his life, Mallet, till he reaches the age of 25, Mallet, then he gets a job, Mallet, at least that security be there. Then, Mallet, the right to, Mallet, inherit the property, that is, Mallet, that is
Avatar
always.
can quantify an amount, because if you say that, that will be keeping it vague. Now, tomorrow you will say that we pass the decree and dispose of the appeal. We are very happy. One more disposal. But you won't be happy because ultimately, suppose a medical emergency comes up, they don't pay. You have to move court every time. And also, regarding the quantum, they may raise a dispute. You may raise a false dispute. Both of you may do that. We are not blaming them only. I mean, how will then it will have to come to court every time?
Mallet, we discussed, Mallet. I have also suggested if it comes to 20 till the age of another till he.
So what is the quantum?
Mallet, it comes to around 30 lakhs.
30 lakhs.
But Mallet, with medical, Mallet, if something can be secured, but the wife, Mallet, she was, Mallet, suggesting that if it is monthly, it is better. At least she would know how much will be the expenditure, and she can always, Mallet, apply for enhancement if the expenses are
that she can. Even in permanent
so,
alimony,
Mallet,
you can.
if that
Circumstances
remains,
change.
my lord.
Yes, Mr. Chakko, what do you say to alimony?
My lord,
Permanent alimony, you have to pay. You cannot say anything. But you have been paying also 20,000.
yes, my lord. I shall, my lord.
What should be a reasonable amount, Mr. Chakravarti?
Exactly now, I cannot say. I just
Take instruction. Take instruction. And you can't prepare on this Raman versus Kavita.
not the owner of the shop. Yes.
We'll hear you on that. What is your answer
Fine.
to that Raman versus Kavita? Very well. একটা judgment, একটা order record. the present appeal has been preferred against a decree of divorce obtained by the respondent husband. Full learned counsel for the appellant argues that the counterclaim for restitution of conjugal rights filed by the appellant wife was not disposed of, although adverse observations were made in respect of the same by the learned trial judge. Full next para. During arguments, learned counsel for the appellant is apprised by the court that the court may take into consideration the decision of Rakesh Raman versus Kavita, reported at 2023-17 SCC 433 while deciding the case, and invites arguments from the appellant on the said judgment, in particular said judgment. Next para. In order to enable learned counsel to come prepared on the said judgment and to conclude their arguments, the matter is adjourned till July 15, 2026. July 15, 2026. Come back on that date, complete your arguments and deal with Raman versus Kavita also. Mr. Chakraborty, you also in the meantime, arekta line add koda. Learned counsel for the parties are also requested to take instructions from their clients regarding what would be an appropriate amount of permanent alimony in the event the divorce decree is sustained. However, it is made clear that the above observation is not conclusive, but only to indicate the only to give an opportunity to the parties to come prepared on such aspect as well. So take instructions, lump sum, Mr. Chakraborty, take instruction as to the upper ceiling of how much you can pay, your client can pay. Lump sum, how much? You also take instruction, what will be the lowest, obviously. And regarding monthly alimony also, whether this arrangement can work out.
That can it be on 16th, my lord?
16th, very well. 15th na karo, 16th karo. 16th. Come back on 16th. Thank you. বলে নিচ্ছি হারবে তাড়াতাড়ি হারিয়ে লাভ কি আছে এখন অ্যালুমিনি পাচ্ছে সেটা কমে যাবে হয়তো এটা নিয়ে পাস ওভার ছিল কিছু পাস ওভার গুলো নট টু দেখুন ছেড়ে They're not there.
No, my lord. I am appearing on behalf of the respondent.
Not today, not today. Grateful.
My lord, may kindly give a returnable date in this? My lord,
These matters are taken up on Wednesdays and Thursdays. Hearing matters. Not today, not today, not today.
16, my lord.
You're appearing, sorry. Yes.
No, my lord, only thing is this, my lord, the fag end of my life, my lord. I cannot go against the resolution of the bar not to attend from 2 p.m.
This is, first of all, we disagree with you on both points. This is not the fag end of your life. And secondly, you can go against the resolution, but we won't compel you to.
My lord,
not today.
Against my
do not do that.
My lord,
not today.
My lord, we have learned from Swamiji, when there is a clash between your head and heart, go by your heart. I go by my heart, my lord.
We abide by your heart, not today.
My lord, kindly take it on Wednesday, my lord.
That you cannot say once you say that.
No, my lord, only thing is that I am also, my lord.
Let there be some suspense in life.
No, I'm the unfortunate husband. My lord, not only my client.
No, by being a husband, you are unfortunate.
Yes, myself also, in my life also unfortunate. But I lost my UI when I was 44.
Oh, so, you are speaking out yourself.
No. I'm my client.
We take up these matters only on Wednesdays and Thursdays.
Yes, my lord, kindly see.
Come back on Wednesday.
Yeah, my lord, we will be there. Kindly see. When will be lordship's pleasure to make it part-heard. Then my lord will feel sure, safe and secure.
If you make it part-heard, then it will be an appearance on your part. Then you will be violating the resolution of the bar. So we cannot compel you to violate the resolution.
Kindly.
Next. Yes, Mr.
I appear on behalf of the appellant.
You can start the matter, but they're not there.
They're not there, my lord. I don't want to.
I understand. You'd never want to.
But I'm there, my lord, but I'm led by Mr. HON'BLE in the matter.
But I am ready otherwise.
Since there is a resolution, my lord, I would only pray.
Why are you keeping for the last? Say that. On the prayer of the respondent, let the matter stand adjourned for the day. Naam gulo record. Not today, nothing. You would be asking for time. Then not today. Yes.
Appear for the appellants, my lord.
Yes. Then.
My lord, there are two appeals. Because, my lord, there was a plaint for, my lord, money decree filed by the yes. Before, my lord, taking your lordships through the paper, the respondents before your lordship filed a plaint. And I had for money decree, my lord, of course. And then, my lord, I had taken a written statement, and with a counterclaim, my lord, they had filed a written statement with regard to that.
Counterclaim for money also.
Yes. And, my lord, there was a decree. Their suit succeeded. My counterclaim failed. Therefore, these two appeals before your lordships. Now, my lord, there are, my lord, papers galore to give your lordships a snapshot of the total, my lord, list, my lord. The allegation of the plaintiffs before the learned court below, or my lord, the learned subordinate court, stand corrected, my lord, was that there was an agreement for sale entered into between these two parties, my lord, in 2nd of September 2012. And it was, my lord, for sale of land by my client to, my lord, the respondents of a land considered with buildings in DAG number 1734. This DAG number is important. And, my lord, equally important is the Khotian number 4492, which stood in the name of my client. Now, my lord, the allegation was that my client also received some, my lord, monies from them. However, my client did not, my lord, carry out the execute the deed of sale. Therefore, my lord, they had sued for, my lord, money. And their case is that there is another sale deed.
Money means refund of that
money with interest.
interest.
Yes.
Not any compensation over and above.
No, my lord.
Very
My
And
lord,
your counterclaim was?
my lord, my counterclaim, my lord, is regard to the second point, my lord, I was just placing before your lordship that admittedly there is a second deed. There is a sale deed. There is a sale deed between the same parties.
After the agreement?
Yes, same DAG number. But the Khotian numbers are different. That is the allegation of the plaintiff. So, different plot of land. Therefore, this sale deed has not been executed pursuant to the agreement for sale. That was, my lord, the plaintiff's.
Was accepted by the trial?
No, not accepted by me. My lord, my whole case, my lord, something, my lord, had happened, my lord. I do not know. No shred of witness or evidence was produced on my behalf before the honorable learned subordinate court. However,
deed was produced.
My lord, the agreement for sale was not produced. The deed was produced. I will rely on.
They did not produce the agreement for sale.
No.
Because the agreement was seized by the police.
Police.
office And it was misplaced in the Malkhana and it was given in my examination.
It was an unregistered agreement.
So, my lord, to make the matter very short, I will rely, my lord. I had already indicated your lordship the LR DAG number 1734.
Sale deed was exhibited by them.
Yes.
To show that it was in respect of a different plot.
Yes.
What is your defense?
And my case is that the sale deed is with regard to the with regard to the same property and pursuant to the, my lord, same agreement for sale. However, my claim was that in the agreement for sale there was an agreement for 19 lakhs consideration. However, my lord, by coercion it was made 14 lakhs and I was coerced to sign on that deed.
Oh, you were a baby, suckling baby.
Oh, my lord, I was taken to somebody's chamber, my lord. I was threatened and I was coerced. These were the allegations.
Your chamber. Their chamber. Our chamber.
I cannot say, my lord, I was not before the learned subordinate court, neither before your lordships when these matters were admitted. It has come to me later on.
So why did you ask for the money?
My lord, my contention is that it is the same property. It should be 19 lakhs and I have received far less. So I want the rest of the money.
Sale deed consideration. What is the sale deed consideration?
14. And that is the coercion.
What ridiculous sort of counterclaim this?
Yes.
Yes.
My lord, I will not play hide and seek with your lordships. I am here to assist.
Play hide and seek. This is I mean.
Yes, of course. However, my lord,
peculiar
as far as my counterclaim is concerned, I know the fate of it. Especially
in the morning, we are taking surrender matters. Everyone is coming and surrendering. We leave it on you, and we are
my
in a
counterclaim possibly, but to their claim, I can show it within 5 minutes. I will be able to.
Would you like to prove the identity of the subject of the deed, the property which is the subject of the deed, and the agreement? How did you prove that identity if you did not produce any evidence?
My lord, I do not need
is
to.
this?
I did not need to go into the agreement for sale. I will just place before your lordships the deed of sale and the, my lord, what has been held by the learned
The
subordinate.
agreement has been referred to in the deed.
Yes. No, it has not been referred to.
Then what would you show?
I will show that the same dag in the same Khotian has been sold to them. Their case is that
The deed that will be evident.
Yes.
See, show.
My lord, the copy of the deed is at page 130.
But deed was also not exhibited.
Yes,
It was
yes,
exhibited
by them.
by them.
No, nothing was exhibited from my side. No
Yes,
witness
we know.
also. My lord, I do not know
Great.
how that happened.
136 page.
136, your lordship has found the deed.
Yes.
So, my lord, before taking your lordship to the schedule, which is at 146, my lord, their allegation is that the agreement was to sell land 1734 dag number under Khotian number 4492. However, by this deed, Khotian 4488 and 4489's land was sold, the same dag number. That was their allegation. My lord will kindly peruse the Tokoshil minute I will place before your lordship. Jelao District Registry Office, Howrah, Additional District Sub Registry Office, Domjur Thana, Jagacha, Shamil, Mouja, Uttor, Bakshara, Grame, jail number. My lord, these all will match. There is no, my lord, dispute.
How did they prove the agreement? You admitted the agreement.
Yes.
Your client admitted the agreement. So the agreement, the measurement of the land and the everything else apart from the dag number was same. Tallied with this deed.
The case made out by them was accepted by my client, except for the assertion that the land in a different Khotian has been sold.
Yes. No, apart from the Khotian, everything else
matches.
Matches.
Yes.
The extent of
Everything.
Oh.
And there is no dispute regarding that. No dispute by the plaintiffs.
Achha.
Only Khotian. That is all. So, my lord, if I may read on, Howrah Municipal Corporation 45 নম্বর ওয়ার্ডের এলাকাধীন রিভিশনাল সেটেলমেন্টের 1015 নম্বর খতিয়ানভুক্ত হাল LR 4488 4489 নম্বর খতিয়ানভুক্ত যাহা বর্তমানে বিক্রেতা আমার নামে 4492 খতিয়ানভুক্ত।
As per the agreement, what was the Khotian?
4492, which is my Khotian. And as per them, a different land in the previous two Khotian numbers as mentioned over here, 4488 and 4489 has been sold to them, and not the land under 4492. But a plain and simple reading of this will show that the two Khotians reference was only made, and it has been made clear, jaha bortomane bikreta amar nam 4492 নম্বর Khotian. And my lord, if I may also show to your lordships, the exact opposite has been, my lord, stated in the, my lord, judgment. Yes. Two places from the judgment I'll show your lordships, my lord, if I may take your lordships to there. Page number 89, my lord. My lord, the third paragraph, this description in the LROR shows that piece of land agreed to be sold by the defendant has not been sold to the plaintiff. Why I show this to your lordship? Because this was what was passing through the honorable court's mind, however, based on LROR records. Number 2, which is, my lord, at page 91, the penultimate paragraph, I find from these documents, starts with these lines.
Which page?
Page, my lord, 91.
Yes.
My lord, the penultimate paragraph, I find from these documents that they support the plaintiff's case. From the evidence of PW1, PW2, and from the documents filed on behalf of the plaintiff, I find that although a deed of conveyance was executed by the defendant in favor of the plaintiff on 24/9/2012, which is the one I had showed your lordship, yet it is curious to note that the sale deed has no reference to the agreement dated 29/2012 entered into in between the parties. Rather, the Khotian in the agreement being 4492 was changed in the deed as 3388 and 4489. So there are two mistakes over here. One is the learned court below has completely overlooked 4492 in the sale deed and has wrongly written 3388, which is actually the typographical error possibly. It is also curious to note that the consideration money as stated in the agreement being 19 lakh has also been changed to deed as 14 lakhs. So this is, my lord, palpable, completely palpable. On this alone, my lord, possibly the decree cannot be held. Lord, since I had not tendered evidence,
You
but
cannot
then
go further.
yes, but what happened was I had purchased this land from two persons, Sarkar couple. What they do is they sell me the land. After the sale went through, they go before the BLRO, suppress the fact of sale, and they then mutate the land in their own name in this Khotian 4488, 4489. I find that I go there, I apply for it for correction of record of rights. Those were all corrected. And my lord, my my lord name was entered. This DAG number was entered against my name in Khotian number 4492.
The LR records have been produced apparently.
But not the correct ones, the previous ones.
If you did not produce, then how can we take that? Accept?
Yes, but possible.
But court has also observed that this description in the LRRO shows that the piece of land
yes
has not been sold.
Yes, but my lord, the
4488 and 4489
placed reliance on land records to see the ownership of the land.
Apart from that, was there anything else before the court?
The deed itself, which
that
was
is your
executed.
deed.
No.
Your title deed, the one by which you became the owner, was it before the court?
No.
Then how could the court ascertain ownership apart from what is there before the court?
From what was there before the court?
This deed was executed by you.
Yes, and placing reliance on that deed, the learned court holds that the agreement being 4490 was changed in the deed 4488 and 4489.
Yes, but the court also looks into the LR records, page 89 as you placed.
Lord, with deepest of respect, Lord, possibly LR records cannot be looked into to ascertain ownership and who has sold land to whom.
No, LR records are relied on by the court to corroborate whatever is stated in the deed. In the deed, these two plots are given. 4488
Three plots are given. I'll once again take back your lordship to this.
We can't find any meaning to this sentence in the deed. Anyway, please place it again.
Yes.
That's I will understand
Previously,
why this has been
all right.
Previously recorded and subsequently recorded.
No, it does not appear.
Yes.
HAL. The previous numbers are HAL.
Lord, HAL means LR.
No, HAL means current. The last.
Therefore, LR. My lord, may I read?
LR. No, LR is written. HAL LR means that is the last position.
Yes.
HAL LR 4488. There may be subsequent corrections in the LR era also.
Yes, why not?
So this is HAL LR, the final position.
Maybe
HAL
read on
LR
that.
4488 O 4489. Number খতিয়ানভুক্ত যাহা বর্তমানে বিক্রেতা আমার নামে 4492 খতিয়ানভুক্ত. What is the meaning of this? 4488 and 4489, if you say, how can it be HAL আমার নামে নথিভুক্ত 4492? What is the meaning of this?
My lord, it says খতিয়ানভুক্ত HAL LR so and so and so and so number খতিয়ানভুক্ত যাহা বর্তমানে বিক্রেতা আমার নামে 4492 নম্বর খতিয়ানভুক্ত.
So then you are not selling 4492. You are selling 4488 and 4489. খতিয়ানভুক্ত HAL LR 4488 and 4489. You say the properties HAL LR খতিয়ান number such and such 4489 যাহা বর্তমানে আমার নামে খতিয়ানভুক্ত. So it has been recorded in your name as 4492. But the property actually being transferred is in those. The subject property has been described as
one property cannot be entered into three different khotians, the exactly same property. That is why, my lord, one man, one khotian came into, my lord, place in our state.
That is why we cannot rely on this statement. Jaha amar name 4492 number khotian book.
Yes. My lord, I understand what is passing. I understand what is passing through your lordship when HAL, that word HAL, had it not been there, then possibly
you admit that what you are transferring is HAL LR 4488 and 4489. Jaha বর্তমানে আমার নাম 4492 te, which cannot be obviously.
Double positive.
Double positive? No. Have you described the property anywhere inside the document?
Yes.
The body of the document.
Yes. My lord, the recital possibly starts at page 139.
Yes.
Lord, the exact place, page 141, it starts from my previous owners. Lord, the fifth line from the top, if your lordship reads,
Yes.
The sentence starts at the end of that line, পশ্চাৎ উক্ত বিজন
yes.
ব্যানার্জি মহাশয়ের আইনসঙ্গত বৈধ খরচ কারণ টাকার বিশেষ
See, come to the fourth last sentence of that page. এলার সেটেলমেন্ট রেকর্ডে চিন্ময় সরকারের নামে 4488 ও দীপালি সরকার নামে 4489 নম্বর খতিয়ানে such and such. So there you say 44 those two dags.
তত চিন্ময় সরকার ও দীপালি সরকার খরিদ
আচ্ছা
And one more thing, just now they have stated that they don't know, they have applied before the vendors have applied before the BLRO for mutation, and they have got these two numbers which the defendant was unaware of.
No, I was not unaware of it.
Just now, yes, he was not
Of course not
and it is
unaware.
written in the deed itself.
We'll just go through the detail. Yes, come to page 142.
Yes.
In your favor actually. পশ্চাৎ দলিলদাতা আমি খরিদিস্তক such and such will be middle of that page, about 10 lines from the
Yes, there is a line also.
Mutation করে এলআর সেটেলমেন্ট রেকর্ডে 4492 নম্বর খতিয়ানে হিসাবে লিপিবদ্ধ করিয়েছে বলেছে ভেতরে।
So in the recital it is there that previously it were under two different khotians, 4488 and 4489. Thereafter I have
don't get tense, we'll come back to you.
Thereafter we have corrected the records of right to bring it under 4492. So the schedule in light of the recital is also clear now. And my lord, if your lordship goes back to the findings of the learned subordinate court, the learned subordinate court unfortunately has completely glossed over that 4492 in the schedule and also in the deed, because it said it has been now changed from 4492 to 4488 and 4489. Therefore, the learned court below did not even see that words 4492 written neither in the recital nor in the schedule, and proceeded on the basis that the
LR records.
Yes. My lord, 128 it starts. My lord, we'll see the exhibit 1 at 128. These were all exhibited by them. The penultimate name, it is the plaintiff's name, Kanchonde. This also now stands in his name.
This is a different khotiyan.
Yes, because Kanchonde's khotiyan.
It's after mutation, purchasing the property.
4488, 4489 of my erstwhile owners, 4492 of 4429 is of the defendant, and this is of the plaintiff after they purchased it from the defendant.
We'll continue the hearing on Wednesday, next hearing. Heard in part, for list the matter for further hearing on July 15.
Very good.
Short matter, not a very long.
Your Lordship, there is something which I have to inform.
10 minutes, 15 minutes?
Yes, Your Lordship. Must
Short.
not from.
Yes.
Grateful.